be. Now it should be. Hello, folks over at the Clip channel. Then I maybe should have. Hold on. Dun, dun, dun. Dun, dun, dun. Here. Let's pop that chat out. And there you go. Now, here's the live on Clips. There. Ghost got there before me. All right. Yeah, let's pin ghosts. There's something odd going on as soon as I go over to the... Ouch! Oh. Mr. Jingles. Oh. There. Mr. Jingles, your claws hurt. Please stop whooping with claws out. Ow! Okay, fuck off. Jesus Christ. My poor shoulder is like a needle pin. That's why I'm wearing coats with large shoulder puffs, because Jesus Christ, Mr. Jingles. All right. This, for instance, this is a divorce case.
Provisions of the marital dissolution agreement, and those were set for today by him by notice. He has contacted the clerk's office and advised that he is unable to be here today, and has requested that they be reset. My understanding.
Yeah. So this, as it seems, for instance, this piqued my interest. Okay. So the soon-to-be former husband booked this date, so she had to take time out of her schedule, and then it doesn't show up. So it sounds like initially, like he's like, he's an asshole. At least initially. But let's keep listening.
That you oppose resetting those motions. Is that correct?
Yes, sir.
And are you not able to, when did you give him a date? July 28th is the date that was given to him that would be available for a resetting.
I don't know. I don't have my phone. I don't have my calendar. I work in EMS. I cannot take off random days that have not been approved for anything. I am also stating that I believe that he is doing this he's doing this just to keep control over what's going on right now. The MDA states he has 90 days to do what he needs to do with the vehicle and set up payment plan or whatever with it in regards to our judgment that was in Clarksville. And for however, when I did not agree to an extension, which in the NDA, it states that I have to agree to give him an extension. That is when he started attacking me verbally, saying that I have multiple text messages and multiple missed calls telling him.
Sounds like an asshole,
you know,
to be ex-husband.
I'm going to take you back to court because this is unfair, blah, blah, blah. When he had from.
So this is something, okay, this piqued my interest, not because, oh, let's show him as an asshole, no, but sympathy for her. This, in my opinion, should be a good clip. We might as well check.
From the time of the MDA, of the finalization of the MDA, 90 days to get the car refinanced in his own name, or he had to turn it back over to me. Well, he has not made any good faith efforts into doing that. And I've been in contact with the loan company, and he's been making the payments. However, he has not made any efforts to.
Well, let me interrupt you, and I apologize. I understand what you're saying, and I understand that his motions are to try to modify an agreed order, a marital dissolution agreement that he agreed to. And I understand why that's frustrating for you. They are his motions, and because he contacted the clerk to advise he couldn't be here today.
But he contacted the clerk and like not even an hour before court started.
So if I could finish, because he contacted the clerk to let them know that he was not able to be here. I don't know the reasons why. I don't know if it's a legitimate reason or not. What we would normally do would then be to find out when you were available, and I will set this motion for a show cause as to whether or not these motions should be dismissed summarily. If, you know, and put the burden on him to appear and argue the motion so that you can get this done. So do you know when you would be available again?
Like I said, I don't have my phone for my calendar. The only reason that I was able to be here today is because I work tomorrow, and I work 24/48s. So I don't know.
What about Friday? Are you off? Do you know if you're off Friday?
I am off on Friday. I get off work that morning.
All right, then just plan to be here Friday morning, and we have Dixon Chancery some matters that we'll put these motions on Friday, and if he's
Are
not
we
here,
talking about this
this
Friday?
coming Friday, day after tomorrow.
Okay.
If he's not here, then I will dismiss the motions because he can't file motions to delay the enforcement of a marital dissolution agreement and then not appear and then have months go by where and defeat the operation of the marital dissolution agreement. So we'll let him know that he's got to be here on Friday, or else his motions will be dismissed.
Thank you, sir.
All right, 9 o'clock.
9 a.m. Yes,
Thank
sir.
you.
Thank you.
Okay, so that was more or less a 5-minute clip, just showing how somebody is an asshole. So this is a good contender. I have it written down. And so this have potential to be a 5-minute clip. Now, does it necessarily become one? I don't know yet. It could be interesting if I catch up with this again in a couple of months from now. Oh, here's the resolution. But as it seems, this could be a standalone clip from Judge Wolf's court. Then I'll just skip ahead.
Morning, Judge.
Good morning.
Judge, I'm the court-appointed administrator of this estate. We were in court a couple of weeks ago in the motion regarding Kathy Rundle.
Let me first address this issue. I've got a motion to continue the motion for instructions that's been filed by Mr. Vandervoort, and he represents Mr. Sam Myatt. So he's filed a motion asking to continue Mr. Reagan is here, I assume, in his stead. So before we take up your motion for instruction, I need to hear whether or not there's a basis for the motion to continue.
I am, Judge. So Mr. Vandervoort represents Mr. Sam Myatt, who's one of the heirs. Mr.
Trust me,
Vandervoort,
when I tell you, I know all about this.
you
case, so-
understand, Judge, yes. So he's out of town today and will be for several days and could not be here. That was one of the bases for asking for the continuance of this. The second reason is, Judge, I don't think this case is in a position yet for this motion to even be granted. And I know that's a separate issue, and Your Honor will take it up after deciding this, but there is still the DNA testing that is going on. And so for that reason, even in arguing the motion that Mr. Odle has filed, we're going to suggest that it should be continued.
Is there some urgency about the motion for instruction that would require that to be taken up?
Well, Judge, I've been contacted by several heirs about personal property at my office. And then we were in court a couple of weeks ago. Your Honor instructed me to file this motion, and I did so. I understand what Mr. Reagan is telling me.
Well, I'm a firm believer that if a lawyer is involved in a case and he is out of the state on vacation or whatever, that it should not be taken up in his stead. So for that reason, I'm going to grant his motion to continue until Mr. Vandervoort is actually present and able to deal with the situation. So my thought would be, we just need to find out when he's going to be back and when the opportunity would be present.
Not particularly of great interest here. So I'll just skip it over, waiting for the next case. Let's see here. Okay. So this is what you're watching now is more or less me
What is your name, please?
looking for
Sheila
content
Woodard.
All right.
for my clips.
My
clips
question
channel.
is, will it be just like a bid? I mean, if somebody bids $2 and then $5, it'll just keep going up until, when will it close?
That's right. That's what an auction is about.
Yeah, but, so it'll close that day.
Yes.
Okay.
Whoever, we're not going to, this is going to be, whenever Mr. Odle sets it, it will be a very simple matter. If this mouse was one of the items, Mr. Odle will say, this mouse is the item up for bid. How much am I bid for it? Somebody will bid $1, somebody will bid $2. And when the bidding is done, whoever has the highest bid will get that item, but they have to pay for it that day. And Mr. Odle will keep a record of this person, Sam Myatt, bought this mouse for $25, and he'll have that down. At the end of the day, Mr. Odle will total up how much Mr. Sam might bought, how much you bought, how much everybody bought on those items, and he will have to have a check for those items, or paid in cash preferably, and he will deposit that into the account, and there will be a recording of each item that's sold, and everybody will have a record so that everybody knows that nobody's getting hoodooed. So I don't know of any other way to do it to try to give
Right,
you all a
I
chance.
agree, right.
In an ideal world, you all could get together and civilly disperse these things so that if there's a particular item that you wanted, you could have a particular item somebody else wanted. And that's the way it would be done. But we're in the middle of a lawsuit that the parties are so contentious that we can't agree on anything. So we're going to do it this way.
That's fine.
Okay?
All right, thank you.
All right.
Ask one question.
I
There
don't
are,
know if I want to let you.
there are a number of photographs and which could be duplicated, and certain heirs have brought that up to me as a
Anybody that
possibility.
wants the photographs duplicated, I don't know how we're going to go about doing that. So
Okay, another one. Can't say I. So we could check the entirety of Dr. Wolf's. Just say so in the chat, and I will go through it all while looking for content for my clips channel. So I will be writing we might as well do that instead of me skipping back and forth, because some of these you might be interested in. So let's just keep going at 1.25 speed. Now I won't be, once I post this on my clips channel as separate clips, I won't be in it because it's just the clips, and it will be in normal speed.
I do have one witness.
So are you ready to proceed?
I'm ready.
All right, bring up your client.
Ms. Dodson, do I need to bring up the witness or swear in later?
You have a witness, Ms. Dotson, come on up. All right, this shows he was delivered a copy of the summons on the 20th day of December.
Yes, sir.
This is from 2021?
Yes, sir.
Hey, Jen.
And you
it's your
served
day
a
off, too.
copy of the motion, the notice setting a motion for default on the. All right. All right, all those who are going to testify, raise your right hand. Let's place you under oath. All right, put on your oath.
Ms. Dodson, will you state your full name, please?
Laurel Ann Dotson.
Okay, and you presented with my office certain statistical information that was incorporated into still true information, knowledge, and belief.
Sir.
Okay, and you allege inappropriate marital conduct in the divorce. Could you describe to this his honor what creates the grounds for inappropriate marital conduct? If you just go back over the last 6 to 8 months of the relationship.
Just quit coming home, starting out on drugs, in and out of jail, and then I didn't see him again.
And the divorce complaint says that you all separated in 2015. So is that true?
Yes.
And over the last, before he was served, when was the last time you saw or heard from Mr. Dodson?
5 years ago, he stopped by to try to take Allie, our daughter, to go spend the night with him, and she didn't want to go, and I haven't seen him since.
Okay, and has he left you without helping you in paying bills or rearing the children or anything?
I haven't seen or heard from him. I've got nothing.
Okay, now, do you all have two minor children left?
I have one,
One minor child left, and what's her name?
Aaliyah Dotson.
And how old is she?
She is 6/20/11.
Okay, and you had signed and notarized a proposed parenting plan that's been filed with this court. Would you like to adopt that? Okay. And,
This won't be a clip on my clips channel because
had,
it has names of kids and stuff, so this won't
don't-
be in.
You're not aware if he's,
Now, so this is are some of my ethical, moral things when it comes to stuff like that. Kids' names, gone, out. No, not going to happen. Grape, you know what I mean? Things, no. If it is a hearing about a rapist getting his ass handed to him or her in court in sentencing, yeah, show the asshole to the world. Stuff like that. But not the actual things with names and stuff in it. Hey, Inspire member for 4 months. Thank you so much. Don't catch you live much. I'm in Oz saying hi. Hi. So these are some of the things that I count in as, yeah, that will never be a clip on either of my channels.
Work or anything, or has a job or any income?
Only thing I know is he's in the homeless camp, so I don't know of any employment.
Okay. And you've also tried to find him in that homeless camp and couldn't find him there.
I've tried through his sister who also hangs out in that area, and I
And what was your gross yearly income?
around 21,000.
Okay. All right. So around 21,000, he probably makes zero. So I guess, Your Honor, we can put his income to $1,256.66.
You would impute it according to minimum wage, is that what you're
Yes.
saying? All right.
Okay. Now, in the proposed permanent parenting plan, you have 365 days to his zero. And that you're proposing that if he wants parenting time or if he comes back around, he's going to have to file an appropriate petition with the court. Now, there's also another issue. Did you have a child during the marriage? Okay. And who was the father of that child?
Jan Darwin Black,
And do you know where he lives now?
I do.
Have you been searching to find him since the child was born? Has it been difficult to?
Is the child that you're talking about not one that's on the parenting plan?
He's not one on the parenting plan, Your Honor, and we are filing a petition. We think we know where he is in Stewart County, have him served with that. So Mr. Dotson can be disestablished as the father.
Well, you've alleged in your complaint there are 2 children born. One's now an adult, one is 14. Is
Yes,
that correct?
and then now there's a
4-year-old.
4-year-old boy that's not Mr. Dotson's.
Well, that child is not a part of, you don't allege that,
No, I
even the
don't.
existence of that child. So there's no reason to go into that. You're going to have to deal with that in a separate proceeding.
We're going to do that in juvenile court in Stewart County. All right. Now, is there any furniture, furnishings, personal belongings, or anything that he has of yours, or you have of his? Y'all have same bank accounts, anything? Y'all have anything together?
No.
Okay. Not even a fork? All right, Your Honor. I would pass the witness.
I don't have any questions. You want to put on your other proof?
Okay. Sir, what's your name? And how long have you known Ms. Dotson? Okay. Okay. And are you, do you listen to her testimony? Does it seem like that was fairly, you cooperate with some of that stuff? What do you mean by that?
She works at a company. She cleans my house. She works at a farm of a good friend of mine, Chambers. It's a sanctuary. She works at a popcorn place. She works herself to death.
And do you know of Mr. Dotson being around?
Never seen him.
Never seen him.
Never.
She's been left having to rear the children herself.
All right. Ms. Dotson will be awarded an absolute divorce on the grounds of inappropriate marital conduct. She's awarded all personal property in her possession. He is ordered to pay any debts that may be incurred in his individual name, and Ms. Dotson will pay any debts in her name. I will adopt her proposed parenting plan designating her as the primary residential parent for the one
Yep.
remaining minor child. Child support will be set based on the income, the proof of the income, which according to what I'm understanding is minimum wage for him and 21,000 a year for her, 0 days for him, 365 days for her. And
Yeah, I think
assume
that's
that
fair.
does your
I
is your
think
child
that's
covered
fair.
by a 10 care?
Yes.
Okay. Then there's no insurance issues. She'll continue to be under that.
Do I need to do a whole new parenting plan? Or?
No, we
Okay.
can use the parenting plan you've got. Well, yeah, you probably should do a new parenting plan because this one's marked as filed as a proposed. This one, you need to put one that's final parenting plan.
I'll do it.
All right.
Thank you, Judge.
Thank you.
Yeah.
All next case.
Still won't be a clip I'm going to use.
Good morning, Your Honor.
Good
This is
morning.
actually an easy one this morning. This is a motion for judgment by default. This is an action to quiet title. Ms. Ferris, the plaintiff, was married to a Patrick Cale Ham. They were divorced before this court in 1994 on the grounds of irreconcilable differences. Their MDA, which was incorporated into the final decree, provided
Yeah,
for their
I meant Judge
continued
Wolf, not
co-ownership of
Dr.
certain
Wolf.
real property as co-tenants with right of survivorship, but neither the MDA nor the decree gave the kind of specific deed reference that would allow an otherwise ignorant title examiner to confirm exactly which dirt was being talked about. And Ms. Ferris is now enjoying unmarketable title to that property. So that's what we've done. The defendants of this action are, of course, the known devotees of Mr. Cam, as well as all unknown heirs and devisees. We've served the ones that we knew of personally. We also served the unknowns as well as the out-of-state defendants by publication. 30 days has passed.
If
since the
if you're wondering,
fourth
this is civil
publication in the
court.
newspaper, and we are asking the court to enter judgment by default.
All right, your motion for judgment by default is granted since there was no opposition filed.
Thank you, Your Honor. I
Thank
have a proposed order, which,
Sometimes these can get nasty if both parties show up and one is a real asshole. But as of now, it seems like I mean, the first clip we saw, yeah, that is a contender for being a separate clip on my Try and Watch Clips channel, which is pinned on the top of the chat. If you're on my channel, my main channel, and if you are already are over there, hello, thank you for being there.
Thank you. Signed your order, Mr. Region.
thank you, Your Honor.
Thank you.
We filed a motion just to deem the assets distributed as has been indicated on the inventory that we filed, or alternatively, that the property previously received by the surviving son, who is Ms. Jackson Smith's client, be returned to the estate, and there be a sale of all property on the inventory and proceeds deposited with the court for determination of how they need to be distributed. That's kind of based upon the fact that the inventory was filed more than 10 months ago, and it's personal property, and Eccles, quite frankly, just wants to stay closed and
Yeah, she got the property
not have
by
this to be-
default. How
Smith?
is
Yes,
my
sir, Your Honor. I
Yeah,
emailed Mr. Odell back in March and asked for a clarified version of the inventory because the inventory that was filed with the court, along with his application for letters of administration, was notated in some areas which were illegible. It had already been typed, and I asked for a Word document so that I could go over it with my client. I never received a response to that email. When I received Mr. Odell's motion set for today, I let him know that I was not available today. In fact, right now, I'm supposed to be in a doctor's office in Nashville, Tennessee. And also reminded him that I had requested a Word document that clarified what was in the inventory. He advised me that I did not need a copy of the inventory, that one had been filed with court. Your Honor, like I said, it is notated. Not only is it notated in handwriting, but it is notated in handwriting that is difficult to read. Some of it is scratched out. It is also our position, Your Honor, that some of the personal property that is currently in the possession of the administrator does belong to Mr. Eccles, my client. My goal, again, was to go through the inventory with my client, have him identify which items of personal property he believed to be his, and then to discuss those items with Mr. Odell. I would also point out, Your Honor, that there has been a significant delay in this case. When I lost my assistant, I associated my father on this case. He had the case upon his decease, and it took a little while for the executrix to locate the file, provide it to me so that we could begin the process. It's not at all our desire to delay this process. My client is pretty clear on what personal items he believes to be his, but I saw no point in going through an inventory that I was not sure was complete or that I completely understood to be able to explain to my client.
Let me interrupt you and just say, the court file contains an inventory that is not notated on at all. It's very clear.
Well, I can show you my copy.
No, I'm just saying though, if you need to get a copy of this, there's no other reason the clerk can make you a copy today. And when you leave here, unless you need to head out as quickly as you can to get to the doctor, but you can have the clerk mail you an unnotated copy. But obviously, you would have the right to have that copy. It sounds like to me this is premature to close the estate. It's also premature to order the return of property. I'm going to allow Ms. Smith to have an opportunity to have a clear copy of the inventory, and you can obtain that from the clerk if you choose to today. And then from that point forward, I'll allow you to try to resolve the issue, and if not, you can set your motions back on the docket.
Usually in divorces and stuff, one party is being a jerk.
Doesn't matter.
I'm-
We're going to
I'm-
give her,
I'm looking at it, Judge. I mean, I didn't know.
we can give you a legible copy today, and that solves the problem. So you'll see the clerk, she'll give you a copy of that, and you'll have the clerk run a copy of the inventory, your deputy clerk run a copy of the inventory, please.
Thank you, Your Honor. That
Right.
concludes my business.
Yes, ma'am.
Okay, for you who wondered, I'm currently at 192 subscribers and 300 valid public watch hours. So I need 308 more subscribers and 2,700 watch hours. I mean, it will probably get there eventually. It will probably get there eventually. All it takes is one clip that gets viral. Well, that's all it takes. I have one on my main channel, one clip that is currently at 24,000 views.
Good morning.
And if I can get one of
Both of
those
you
on
raise your
my
right hand.
Twitch
Let's place you
channel,
under oath.
yeah, I'm good.
One question that I have, you have filed a proposed parenting plan as required by law, and you have shown the incomes that each of you have, that the father's gross income is 3,400, the mother's is 2,560, and that the father will pay child support, but the amount that you that's supposed to be paid according to the child support guidelines would be $315 a month, and that was not filled in on this copy. Do you have another copy of the parenting plan that has the amount filled in correctly?
I was told to bring this than on completion of child parenting class.
Right, those are two different things. The parenting plan that you have filed is supposed to be a part of the final decree. And I can sign off on this one, but I need you to agree that I can fill in the $315 a month. Is there any dispute about that being the correct amount of monthly child support? That's according to the child support calculations that you attached. All right, then I will fill in $315 a month. All right, and I'm going to initial that as having been done. That will be paid monthly. All right, then both, have you placed them under oath? All right. You are Amy Nicole DePaz. Ms. DePaz, you have filed a complaint for divorce that's using a form the state provides online to individuals wishing to represent themselves. That contains certain statistical information. Is all of that information true and correct? You have also supplied to the court a marital dissolution agreement, also known as.
Just to make for you who just joined. Usually, I'm running this in 2-point speed or faster if I can, and unless I find something interesting in the first minute, I will skip over to the next case and the next case and the next case. But as you're all already here, we might as well look at Judge Wolf.
The divorce agreement, and that contains certain representations, including your signatures. Is that your signature on that agreement? Do you believe that agreement fairly and equitably divides all of your property and distributes all of your debts? Is there anything between you and Mr. DePaz that is not, Mr. DePaz Fuentes, that is not agreed upon? All right, and are you Hector Anibal DePaz Fuentes?
Yes, sir.
And do you agree that that is your signature on the marital dissolution agreement?
Yes, sir.
Do you believe that agreement fairly and equitably divides all your property and distributes all your debts?
Yes.
Do you, Mrs. DePaz, do you believe that the parenting plan you have filed with the court is in your child's best interest? And you're asking me to, I believe you've signed off on it, both of you. Yes. All right, Mr. DePaz, do you believe that that marital dissolution agreement also is in the best interest of your child? All right. I need a final decree of divorce. Have you prepared a final decree?
He just told me to bring.
Let me see what you have, and I'll.
For instance, this
All right,
doesn't
You're going to have
get
to fill
to
out
my
portions of
clips.
this.
It's a
Both here, so
standard
both of you will need to fill in on the
divorce
first page. Both of
setup.
you need to fill in your addresses.
I could send you control.
Now, the first he had for the day.
Both of you have signed
With
off on it, so I just need you to fill
The
out that front
husband
sheet
who
that has
keeps
the address. Are you
delaying,
changing your last
that
name?
will probably reach.
If you'll just put your addresses on the front
To,
page and hand that back to the bailiff, then I will grant your divorce and sign off on it.
Will I cover the Laura Owens case if she makes it to a trial? Oh, hell yeah.
You'll have a seat and do that
Oh,
at the
hell yeah.
table. I can take up the next case.
Wait a minute.
You'll raise your right hand and be placed under oath, please.
Look at that. StreamYard has
I
implemented
have a question for you about your parenting plan.
StreamYard has implemented something of the sort of show comments on stage. Yeah, look at that. Down in the corner. They have just implemented it. I did not know that. Nice. Yeah. Ah, good. That way you can see your own comments. Nice.
You don't show the father having any income. Do you know where the father is? Do you have any information about his income whatsoever?
Didn't have any last name.
Okay, you don't think he has any income? Do you know where he is?
I should go back and watch the
So is there
trial
some
and
reason he's not
start putting
working?
clips from the
I have no idea.
Laura Owens first civil
Under the
trial.
law, he has an obligation to pay child support regardless of whether he's working or not, unless he has some verifiable disability that prevents him from being able to work and supply support for the minor child. Your parenting plan does not provide for any day-to-day schedule. A parenting plan that the court has to approve rather, should reflect, when the child is with you, when the child is with him, so that it's a verifiable, something that if an issue arises, then it can be brought back before the court and the court can enforce that order.
Right now, he has no contact.
Okay. How old is your daughter? And he has no contact whatsoever? But yet you have, under the schedule set forth below, each parent will spend the following number of days with the minor children. And you have 12 days for you and 7 days for him.
Those were the days that we had agreed upon. Then he just stopped contact.
So you're saying that right now, he's not seeing the child whatsoever? Well, the problem is I have a duty and obligation to ensure that the law is complied with regarding a parenting plan that's involving your minor child. He can agree. I can't tell by reading this that your child is going to reside primarily with you and not see him at all. I have down that you get 12 days and he gets 7, but it doesn't show what 12 days you get, what 7 days he gets. So I know you have shown holidays, but there needs to be a clarification of that. You have down there certain visits, with a 2-hour visit for him on President's Day, a 2 to 4 hour visit on this day of that. And then you have otherwise put down no overnights until Jonathan gets his own place. The problem that we have is that, number one, you need to have a better drafting of your permanent parenting plan so that it is clear that he does not have any overnight visitation and that the only visitation he has is the holiday visitation. You can spell that out, and he has to agree to it because this is an agreed disposition of the case. But I can't approve your parenting plan in the way it's drafted right now because it's not clear when he can see the child on any other date other than holidays. Understand that, but I'm looking at it from a judge's perspective as to enforcement of an agreement between you and he. If you and he are agreeing on the divorce, and this is why most people try when they have a minor child to at least get some advice from an attorney about how to go about it, because he has an obligation to pay support whether he likes it or not, whether he's seeing the child or not. His obligation to pay support is completely independent of his right to see your daughter. He cannot fail to pay support simply because he's not seeing the child, or else there'd be a lot of men who would do that. Likewise, the fact that he's not paying support cannot be used as a barrier to him being able to visit with the child. So
This part might
therein
be a
lies the
clip.
problem that you've got with the drafts of your final decree and parenting plan.
At
So
the
what I'm going to
4
do is I'm just going
minutes.
to pass this case on the docket, let you try to have a second shot at drafting a better parenting plan. If he's going to have to sign off on it. And if all he's going to do is see this child on the holidays, then he's not getting credit for any days if he is not having overnight visitation. The child support guidelines say that he only gets credit if in fact he is getting an overnight visitation, a 24-hour period with overnight visitation. So if that's not happening, he doesn't get credit. You get 365 days, he gets 0. And that counts towards the calculation of child support. And your child support is going to have to be calculated whether he likes paying it or not, if only minimum wage, as we saw earlier in the day. You might want to get some legal advice about how the best way to draft this thing, because it is a little bit more complex, okay? All right.
Yeah.
All the next case. You have that final decree from the last case.
Hold on. Was that the same lady as in the first? We are at 47. No, it's not the same lady. So two assholes
Give me just a
who
moment.
just took off. All right. Two possible clips. In the first hour of this, of his proceeding. All right.
Yes.
Skip ahead to the next.
Order children,
Okay.
two minor children. Previously, the parties went to juvenile court seeking a child support order. Mr. Wambier is ordered to pay child support out of the juvenile court. As the juvenile court, as the child support agency often does, they only file a petition and state that there's a duty to support, and they don't establish paternity. So we filed a petition with this court to establish paternity of the parties' minor children and to adopt a parenting plan. Excuse me. Mr. Wambier filed, we initially served him. He filed a parenting plan. I asked for the court to interpret that. The court gave him time to amend his answer. We set this for mediation. Apparently, Mr. Whitworth hired Miss Kathy Everett.
Did Mr. Wambier?
Wambier, excuse me, I'm sorry. Mr. Wambier hired a Miss Kathy Everett to represent him only in the mediation. I did not realize that when we mediated this matter last week. He had counsel appear. Miss Everett filed a notice of appearance in the juvenile court case where there was no petition pending. And she appeared in the Chancery Court mediation. And after it was over with, then Miss Salinas, our mediator, notified me that Miss Everett was only retained to attend mediation with Mr. Wambier. So he is here now pro se, but I wanted the court to be aware of that I was under the impression that he had counsel. She had filed a notice of appearance. I didn't pay close enough attention, and that her notice of appearance was filed in the juvenile court where there wasn't a case pending. I did file last week a petition with the juvenile court seeking to have Mr. Wambier found in contempt of the orders of this court, as he's in excess of $10,000 in arrears of his support obligation. I have served him with that petition today. I had reached out to Miss Everett to see whether she would accept service. She advised that she would not, that she was only hired to attend mediation. So I did serve him with that petition today, and there's a petition for contempt in juvenile court. And so what we're here today, Your Honor, is on our petition to adopt a parenting plan. We have filed our proposed parenting plan.
Well, I heard earlier there was it he contested parent, that he was the actual parent? That would be interesting to hear more about, but as of now...
Plan, and we're ready to proceed on that. As I said, we had earlier filed a motion back in December for a motion for judgment on the pleadings and to set for a final hearing. He was allowed to amend in his pleadings, and as I said, we're here to proceed to adopt a parenting plan. Just as an FYI, as I said, Mr. Wambier is pro se. Mr. Drake is on the James case that we have that's also on the docket. He has filed a motion to continue. And Ms. Hendricks and I have another contested matter that will take. So I'm just kind of coming up with Mr. Drake has a motion to continue in the James case. So I didn't know what Your Honor was.
Well, before we start in, let me hear the motion to continue then before we start in on this case.
Yes, sir.
Let me first address Mr. Wambier. My understanding is that from what Ms. Roberts says, that you had a lawyer for a limited purpose, but you are not represented by counsel at the present time. Is that correct? And you understand this is for the final hearing to adopt a permanent parenting plan. The issue of child support is in the juvenile court, but this court will be setting a residential schedule instead here. And you are ready and willing to represent yourself on that? All right. You will step aside. Let me step back in the audience and let me deal with this motion to continue first.
Your Honor, are we ready to take up my motion to
I am.
continue? So in this case, there's an issue about whether somebody took an appropriate tax deduction for a child. I thought I had provided appropriate evidence of our tax returns that my clients had filed, but apparently Ms. Roberts informs me that my clients filed separately for one of those years in 2021, and I didn't provide that information. I can get that information, but I can't get it today. Likewise, also, Mr. Barrett, who's married to Susan Barrett, who is the respondent in this case, and she can come on up and have a seat. Her husband is a sheriff's deputy in Rutherford County, and he got called in today to appear at preliminary hearings. I know we were provided a Zoom link for that, but it sounds like that we've got a deeper issue with regards to this discovery. It's probably our fault. I understand that, but also need additional time to provide this discovery that may clear up some of the issues between these parties.
Ms. Roberts?
And again, I mentioned to Mr. Drake, this is a matter I have filed a petition for contempt. I am seeking criminal contempt sanctions. And what we have, Your Honor, is that we've got several issues. Number one, the issue is that the party's middle child has emancipated. And as a result, my client is due a modification on his support obligation. We started out with 3. Oldest one had graduated. Now the middle one has graduated and turned 18. So there's one, their daughter Harper, I think is 11, close there too, and she's the only child left. So number one, I filed a petition to modify his child support. Number 2, I filed a contempt based on the fact that when Your Honor heard this case back, I think in 2020, you ordered that the mother, who is now Mrs. Barrett, previously Miss Susan James, could claim the eldest child every year. Mr. James could claim the middle child every year, and they would alternate the youngest child, Harper, on an odd and even basis. And then lastly, I filed because of interference with visitation with Harper, the youngest child. Your Honor will remember in this case, and again, I won't, Your Honor remembers the problems with these people. And my client, because of the repeated allegations that were gone, agreed and asked the court to allow him to have supervised visitation with children. So what we've got, the contempt portion of this case, when I was speaking, when counsel called me and said that his client's current husband had been subpoenaed to give testimony in court in Rutherford County, I pointed out to him that there was some discovery that was lacking. He sent to me 2 documents. One is a 2023 and a 2021 tax return for George T. Barrett III, which is Mrs. James Barrett's new husband. What we discovered at that point in time was that Mr. Barrett, in fact, in 2023, inappropriately claimed the middle child as a dependent in violation of the order. And Mrs. James filed jointly with him. So we asked for contempt against her. Apparently, when we served him with that petition, or served her with that petition, apparently Mr. Barrett then amended his tax return and deleted Garrett off of the tax return as claiming as a dependent. We never received that information. In 2021, I think, and again, I wanted to tell Mr. Drake because I don't like to pull punches on the situation. Yeah, there you go. He sent me a tax return for George Barrett, which on the top clearly indicates that it's married filing separately and that Susan Barrett filed a separate tax return. Mr. Drake, in looking at that, thinking that this was I assumed that this was Miss James Barrett's tax return, filed a motion to dismiss, alleging that it wasn't. So I don't want, again, I advised him, I think you sent this to me in error. I'm about to put her on the witness stand. We've got a contempt issue. I did not want to have something like that when he thought he had genuinely answered the discovery, and it's not. So we're ready to go forward. My client's entitled to a reduction in his child support. The issue on visitation, again, is going to take testimony, but the contempt issue, again, if it was my error, I would, hope that an attorney pointed it out to me. I felt incumbent to tell Mr. Drake this morning of the error. So we're ready to go forward. I can't agree with the continuance. My client is waited. It's a child support issue.
This is, yes, I heard this case, but this is not a case that I alone can hear the issues that are presented in this petition. So it seems to me that, in fairness to both sides, that the continuance ought to be granted, but it doesn't need to be delayed until I'm available again. It needs to be set on the first available day that can be heard. So, I mean, it does, if you're ready to go on all the other issues, when's the next available date that you have, Madam Clerk?
This is so confusing. Who owes who what? Wasn't there a parenting issue? Well,
I have court in.
who is she actually representing? And who is supposed? So
That's one of the days, if I could, hang on just 1 second. I apologize.
former husband and wife divorced, got separately remarried, and tax. Yeah,
June the 4th is a case where we've got Judge Wolf is in Humphreys County, Judge Turnbow is in Cheatham, Judge Wallace is in Dixon, and I'm going to be.
yeah,
in
this
Dixon
won't be a
on
clip,
the
by the way.
2nd and 3rd, and Cheatham County on the 4th.
First of all, they are mentioning
On the
the
5th.
names of the children, so that
And
won't
I
be a
just say
clip.
that so Judge Wolf understands that he has 4 days of court without having to deal with me in Humphreys County.
And folks, if you wouldn't mind, so jump over to my Trial Watch Clips channel and watch there. I need the hours.
I have a little argument.
And it's pinned on the top of the chat. Subscribe if you haven't yet. Once this stream is over on my main channel, it will go to members only. So then if you want to rewatch it, you're going to have to go over to my Trial Watch Clips channel.
July what?
Fine, sir.
July 1st is fine with me, Your Honor.
My client informs she's going to be out.
Judge Fleischer, yeah. Is he up again?
I'm here on Hickerson on July 8th, and I am here on the 9th in Carbone versus Carbone. I have 2 final hearings in front of Judge Lockhart Mash on either one of. I'm here either. I'm just saying I'm here either day. I have Hickerson
I have a
versus
matter
Hickerson.
scheduled in Smyrna Metropolitan Court.
Which day?
8th, sir.
But what were the days in July?
8th and the 9th, sir, I believe.
Well, Mr. Drake, I mean, this is a motion to continue at your request, and I understand that you need it, but there's going to have to be some consideration that this doesn't need to be delayed extraordinarily
I
long.
can get the DUI reset on, it's on. 8th. That was just said yesterday. We
All right. July the 8th.
July the 8th. Thank you, Your Honor. And again, I appreciate you taking it up.
Thank you, Your Honor.
I didn't want him to have to sit here all. If we.
All right, let me ask this other question then before we begin the Whitworth versus Warmbier. That leaves us with the Willie versus Jones case, Wiley versus Jones or Willie versus Jones, and that is you and Ms. Hendrickson, and that's a final hearing on, without going into, what's the estimated time on that one?
Oh, hello, folks over at Trial Watch Clips channel. Good to have you there. Judge Fleischer, because I know Dali was connected to Judge Fleischer's Zoom feed, so he live streamed those. But then apparently Judge Fleischer decided, after large amount of complaints from attorneys, that they didn't want to be on
We'll
YouTube.
get to when we get to it. Then.
So we
go back to Whitworth versus
apparently
Warmbier.
he cut that down. So no more Judge Fleischer.
Well, let's go ahead and take our mid-morning
Foreseeable
recess now.
future,
We'll be in recess for 15 minutes.
which is
All
really,
right.
really sad, because that is a judge that is very, very clippable. Okay. Pause and
Seen him in a year now.
nope. They're back.
You'll come to the podium. You're representing yourself. You'll be held to the same standards as a lawyer. So.
Your Honor, I haven't seen my children in a year.
Oh,
You have not seen him in a year now?
That's correct, sir. They have been withheld from me for a year. I've made numerous attempts at contact. I've offered to send money for,
oh, this is so sad when people are being withheld from their children, no matter which parent is doing what. If there are no criminal charges or anything, just a dispute between the parents, it's so sad.
birthdays, for events. I've offered to come to Tennessee to pick them up. I've either been ignored by Ms. Whitworth or been told that we need to wait until paternity had been established because it was not established. This happened, or this began April of last year. After paternity was established on our last visit to court, which was something around 4 months ago, I did contact Ms. Whitworth and ask if I may see the children now that paternity had been established. She said we are going to wait until the plan has been finalized. I am in arrearages of, I don't know the exact total. I would assume it's close to that $10,000 mark. It was wrong of me, but I tried to use child support as a means of leverage. I did tell Ms. Whitworth that that if she wanted the child support, she would need to let me see my children. I did hear a case you had presented earlier, and I have an obligation to pay child support whether or not she's allowing me to see the children. And that's my fault. I'll begin getting back on that schedule starting at the beginning of next month. My schedule currently sits, and I still believe it to be in the best interest of the children, where all holidays be split on even and odd number. I would get them even years, she would get them odd years, or vice versa, however the court would see fit. For vacation days, anytime the children are out of school for greater than a week, Ms. Whitworth and I be allowed to split that time. Anything that is a week-long vacation for the children, we would rotate even years and or odd years. Anything that was 2 weeks or greater, I would get them for 1 week, she would get them for the next week. As it pertains to summer breaks, I would get them for the month of June. The next year, I would get them for the month of July. Again, just rotating even and odd time schedule as far as the years go. I'm asking for joint decision-making for everything educational, everything emergency and non-emergency, as well as how they view religious upbringing and extracurricular activities, especially with the extracurricular activities. I can show good faith in if I have the children and they are engaging in cheerleading or any type of extracurricular activity, cheerleading, football, baseball, such as that it would be my responsibility to court them to and from. So I think Jake or Raiden is getting quite into football, and I think that would interrupt like a July visit. But I think that's something that, Ashley and I could come to an agreement on as far as, visitation throughout that month.
I'm going to give you a chance to testify, and what you're saying now is just in the form of an opening statement, so it gives me an idea of where you're going. All right, if you'll have a seat there, Ms.
Yes, sir.
Roberts is the moving party, so she'll be allowed to put on her proof first, then I'll hear from you.
Yes, sir.
All right.
This might be a clip,
All right, Mr. Wambier, if you'll come around, we're going to put you on as the first
unless
witness
they start mentioning the
for
names.
Mrs. Whitworth. Raise your right hand, be placed under oath.
Oh, okay, this is the same case.
Mr. Walmer, you understand that you're now under oath?
No, she's on.
When you were
Zoom.
giving your opening argument to the judge, you were not under oath.
Okay,
Okay, so you now understand that you swore to tell the truth,
that's correct.
and you understand that the statements that you made before the court on your
Yes.
opening statement, will you affirm that all of those were true?
Yes, I would like to, so I don't commit perjury.
Mhm.
December of last year, I was allowed to visit the children for 30 to 45 minutes. That was the only time that I saw the children. It was something that I did forget to mention in the opening statement, but other than that, all else remains true.
Okay, so you are admitting that you are significantly behind in child support.
Yes, ma'am.
You are admitting that you knew that you were willfully behind in child support, that you knew you owe that obligation,
Yes.
correct? And that you used the child
I can
support
try. I can try.
as a weapon, basically, against.
Yeah, I can try to edit out the names of the minors. There is one of these functions on one of the editing programs.
Mrs. Whitworth to try to get some type of agreement on visitation. Is that correct?
Weapon is a strong word.
Well, what word are you going to use?
I'm sticking with leverage.
Leverage. Okay, but you're stating under oath that you're willfully withheld paying child support and you used it as a leverage against Ms. Whitworth,
I did,
correct?
yes.
And you understand that today I've served you with a petition for contempt of court for failing to pay child support.
Okay, so this is the same case. All of a sudden, this got more interesting because I was under the impression that he wasn't there. Now it gets interesting.
Did you have an opportunity to read that petition?
Maybe just the
I was able to glance
testimonial
over that
part.
petition.
I don't know yet.
But again, you understand that your statements before the court, and we have a court reporter down here, that were true and correct. Is that correct? Is that correct?
That is correct.
Okay. I just wanted to verify that at this point in time, and then I'll recall him at a later date. I just
All right,
wanted to.
Mr. Wambier, if you'll step down, please.
Hmm.
For the record, Ms. Roberts, we are correct. I am correct that I am not dealing with the child support issue at all, correct? Well, clearly, the question of payment of child support or lack of payment of child
Yeah, my initial thought about this case was everything was a bit confusing, but as he stated, yes, he's the dad. Yes, he should have paid child support. But using it as leverage to see the kids, I can understand where he's coming from, trying to do that, even though it's wrong, because he wants to see his kids. But this so far is just one side of the story. I'm hoping we get to hear the rest of it.
support, and the reasons therefore are also factors that the court can and must consider in determining the appropriate parenting plan. So I will obviously be allowed to, or will be considering that when we get to that issue. Call your first witness, your next witness rather. Ms. Whitworth, if you'll come around, please.
Yeah, why did you withhold the kids from their dad?
Ashley Nicole Whitworth.
Whitworth, where do you reside?
I live here in Charlotte.
And you have two minor children, is that correct, with Mr. Nathaniel Warmbier?
Yes.
And what are their names and ages?
Raiden Warmbier, and he is 10. Renoa Warmbier, and she will be turning 5 in July.
Okay. Now, Raiden, is he in school?
Right now he's on summer break, but yes.
Yeah,
he goes
this
to
will be
Charlotte.
edited
And what
out.
grade is he in?
He's going to 5th.
Fifth grade, and he
The
attends at
names
Charlotte Elementary.
will be bleeped.
And how you pronounce your daughter's name, Raina?
Renoa.
Renoa.
Yes, ma'am.
Renoa is 5,
Mhm.
and she has not been in school. Is that
No,
correct?
Correct.
Will she start kindergarten in August?
In August.
And will she be going to Charlotte Elementary with
She
your
will.
son?
Yes,
Do you have any other children in your household?
I do.
And who are they?
Jacob Bryant, he is 13.
Okay, and he is your biological child, is
Yes.
that correct? And what grade is he in?
He's going to 9th. He'll go to Creekwood.
And he will be going here on the north side
Mhm.
of Creekwood, is that correct?
Yes,
Okay. Now, you currently live with someone, is that correct?
correct.
And you're engaged and
Yes.
married. What is that gentleman's name?
Joshua Barber.
And ma'am, what do you do for a living?
I work at the Dixon County Sheriff's Office in the jail.
Okay. And how long have you held that position?
8 years.
And what hours do you work?
I work 7 to 3, Monday through Friday.
Monday through Friday. And your children are in school. Do they have any type of daycare, or who keeps them when you're at work and they're not in school?
Renoa goes to daycare. The boys stay home
And Renoa is still going to daycare
until
through the
August.
summer.
Yes,
And then will she go to before care and after care? Because
No.
you have to be there at
No.
7, but you can drop her off.
Yes.
Is that correct?
yes.
Will you need daycare in the summer?
No.
Well, who will keep her in the summer?
The boys.
Now, where you live here in Charlotte, is
I
that
do.
correct?
Yes.
Now you and Mr. Warmbier had a relationship together, is that correct? How many years were y'all together?
11. We were together from November of 2011 and split January 23.
And as a result of, during the time you together, did Mr. Warmbier develop a significant alcohol problem?
Yes.
Tell me about that.
It progressed significantly once he signed over his rights to his oldest child. He started
Oh,
to drink a lot every single day. He did work here and there.
and here's another twist.
But I asked him multiple times to go to rehab. He would never go. He just finally decided to go this last year, I guess,
Did he drink around the children?
every day,
And did he become intoxicated around the children?
every day.
Did his personality and the way that he interacted with them and you change when he consumed alcohol?
Yes. He was very argumentative when he liked to drink.
Okay. And
There's
where,
always a
where were
twist.
y'all? Were y'all living in your home, or where were y'all living?
Mine.
In the home?
I would always rent a home and he would stay there. There was never anything in his name.
Okay. And he moved out when?
January of 23.
Okay, and shortly thereafter, do you know where he went?
I know he was working for Marquette Barge Company, so he went back to the boat whenever he came back from the boat that time. That last time after we split, I don't know where he went, aside from he told me he had a girlfriend. And then he was married and living in Illinois within 2 months. So
Yeah, that would explain that. That's really not withholding the kids from their dad. That is, I have no idea where the fuck you are. I can't just let my kids off to wherever you're currently living.
So he moved to Illinois.
yes,
You know, where in Illinois?
Collinsville,
Collinsville. And how far distance is that between where y'all are living?
approximately 4 hours, 4 to 5 hours, I guess.
But y'all had never gone to court to establish paternity or to do anything.
No,
correct?
just child support court.
And after he left, you filed a petition to get child support.
I did.
Was he paying you something before?
He was paying about $600 a month. And then I asked him one time, did you pay child support, or are you going to send me child support? And he said that he wanted the tools that were in our closet. And I told him he wasn't getting those tools. And he asked me, do you want the tools or do you want the child support? And so at that point I took it to court.
Okay. And so even before there was a court order, he was using supporting the kids as some method against you, as his words, leverage.
Yes,
Is
ma'am.
that correct?
Yes, ma'am.
And so did he quit paying you?
Yes.
And you filed a petition with the state of Tennessee to seek child support, is that
Yes.
correct? To your knowledge, y'all went to juvenile court and his child support was established based on your earnings and his earnings, is
Yes,
that
ma'am.
correct? But there's no question that he is the biological father of these children, is that correct?
Yes.
Now, after he left, did he contact you, come back? And this is 2023, correct?
Yes.
Did he come back and visit the kids? Did he ask to visit the kids? Tell me what transpired.
So we were doing a visitation, so he would call and ask to see the kids. Because I know the kids need their dad and they would like to see their dad. I did let them go with him to Illinois to see his dad, to see their dad. When the issue arose was drop-offs. Hey, can you bring the kids at this time? Well, then that time come and gone, and he's making all the excuses in the world as to why he can't, or it's been changed, such as Easter is really my breaking point. Was we were together for 11 years. He was well aware of what we did on Easter, what we did on all holidays for that matter. But it was, we do Easter at my mom's at 12 o'clock. He picked up the kids from my mom and went to Illinois. And when he had spoken to her and he asked her what we were doing for Easter, and she said, it's the same as every year, my house, 12 o'clock. So he took that upon himself to change our drop-off time to 12 o'clock on Easter. And no, that wasn't it. It was Saturday so the kids could wake up, and then it was
Well, where were y'all supposed to meet?
my mother's house. He
Okay.
was supposed to take the kids to my mother's house. No, I'm sorry. It was going to be Saturday. We moved it to Sunday at 11 because my aunt was there, or my aunt wasn't going to be there. So then it was, I guess, 11. He ended up showing up at 12:30.
And were there other occasions when you had, before we filed the petition in July of 2024, seeking to get a parenting plan
Mhm.
established. Prior to that, were there other occasions that you tried to work with him and set specific dates and times for him to get the kids and to bring them back?
While we were dealing with the parenting plan?
Yeah,
Yes, ma'am.
before we filed.
Yes, ma'am.
He left in January of 2023, correct?
So I guess July, for 4th of July, we attempted to allow him to get the kids and wrote up a petition, and he refused to sign it.
Okay. But prior to that, were there occasions that when he left in 23 up and until July of 24, for about a year and a half, when there was nothing pending other than the child support matter, did he visit with the kids?
I don't remember.
Okay. Were there occasions that he was supposed to pick them up and either not show up or refuse to
There
bring
was a
them back
time where
on
he was
time?
supposed to show up and didn't show up till 11 o'clock at night.
Okay. And so at that point in time, it prompted you to try to get a plan.
Yes, ma'am.
And so we filed this in July of 2024. And again, have you offered for him to come here and visit with the children and to visit?
He came at Christmas. I said that he could come down, or his wife technically asked if they could come, and I never responded to her. And then he asked, and I stated, yes, you can come over and give the kids their Christmas gifts, whatever. He stated that he was allotted at 30 to 45 minutes. He chose to stay 30 to 45 minutes. He was in and out.
But again, previous to that, had he taken the kids and then you thought they were coming back on a certain time and then he would change it?
Before or after we established the parenting plan?
No, before.
Yes, multiple times.
So again, were you concerned about him taking the kids to Illinois and then just not bringing them back?
Yes, ma'am.
On
And
what
had he
basis?
threatened that? Had he ever threatened to take them and not bring them back?
I don't believe so. I don't believe he's ever threatened it, but his demeanor and the way that he speaks to me about things,
It was a
doesn't
concern.
concern, or it gave me concern.
Okay. And again, you heard him testify. I put him on the witness stand. He was ordered to pay child support, given credit for what he had voluntarily paid, and he has failed to, and he's in excess of $10,000 in arrears of support.
Yes,
Is that
ma'am.
correct?
Yes.
Now, and during this period of time, has he talked about, have you received text messages and different things from him that are vulgar and inappropriate?
Yes.
I mean, has he sent you one particularly and repeatedly called you a cunt?
Yes, ma'am.
And threatened to call your place of work, the sheriff's department, and have you arrested or
Mhm.
have you fired?
Yes, ma'am.
Okay. Most recently, has he actually even stated in his emails, as it turns out, when I sobered up, I got to see exactly who the fuck I was all those years?
Yes, ma'am.
All right. That was spoken out loud.
But
in
now
court.
that the alcohol is gone, I've got a degree of clarity of who I am and what I need.
Yes, ma'am.
Have you learned through him that he actually did go to rehab?
I learned through his wife.
Okay. When was that?
Gosh, I couldn't tell you. It's maybe 2 years now.
Okay. And do you have a belief of whether or not he's maintained his sobriety?
He has not maintained his sobriety.
And how do you know that?
He had made a Facebook post speaking about me and my fiance, claiming that my fiance gives his children alcohol.
Does your,
and
number one, does your fiance have children?
he does,
And how old are they, those children?
19 and 18.
Okay. And Mr. Wambear has said that that your fiance gives his children alcohol.
Yes, ma'am.
Is that true?
No, ma'am.
And what, go ahead, and did he make admissions that he had lost his sobriety?
He did. My fiance's ex-wife actually wrote him and said that she doesn't know what's going on, but can you please leave my children out of it? And he, in a response to her, stated that 10 months of sobriety was gone.
And is that a concern for you with your children?
Yes, ma'am.
And again, his drinking, major reason on why y'all separated and aren't together. Is
Yes,
that
ma'am.
correct? Your kids are in school. Do they do any extracurricular activities? Again, I know your 5-year-old is,
Yes.
there's not a lot limited that she does.
But Raiden does do football.
And where does he play ball?
Right now, he plays for the Charlotte Lions.
Okay, and that is a fall sport.
Yes.
And do they start practicing right after in July?
They practice in July, yes.
Okay. Has Mr. Wambear tried to come down and visit or done anything? I mean,
best.
recently, did you get a call saying, hey, I'm 30 minutes out, I want to stop by, or
I did.
when was
We'll
that?
do our best.
2
Some
weekends ago,
don't do their best.
I guess.
Tell me the
Some are
context of what
just
went on.
in it.
So he called me and said,
Because
hey,
of
I'm about
other
an hour and a
reasons.
half out. Do you mind if I stop and see the kids? Originally, I did speak that he could,
Mhm.
but I was thinking of, the kids do want to see their dad. After thought, that's really not good for them either, him to pop in and leave so randomly. So I called him back and said it probably wasn't a good idea.
And again, this was after you discovered that he had
Relapsed.
had relapsed.
Yes,
Is that
ma'am.
correct?
Yes.
And are your conversations always volatile?
Yes,
And who makes them that way?
he does.
Have you tried to include him in the children's day-to-day lives? Do you,
Not anymore, I don't.
why?
Because he always makes it into a fight. He ends up calling me names and I don't have to tolerate that anymore.
And again, texting you but now that the alcohol is gone, I've got a degree of clarity who I am and what I need. You've always been selfish, reckless, and inconsiderate to those around you, even your own kids. Even to your own kids. I stayed a little too drunk to do anything about it, but times have changed.
Yes, ma'am.
Kids in
Listen here,
between
you
divorced
stupid cunt.
parents.
You and Josh is your fiance, is
Yes,
that
ma'am.
correct?
Yeah.
Both should be thanking whatever fucking God you believe in that you still have jobs, that you still have custody of the kids. It's only my belief that the kids need their mama, that I haven't called the state on your ass, and that I haven't written a letter to your sheriff about harassment. Are those typically the conversations that y'all have?
Yes, ma'am.
This just keeps getting worse and worse with your ass. You'll keep trying my patience until I finally do take you for custody. Take care of those babies and use some fucking sense.
Yes, ma'am.
He has a flair of flowery language, doesn't he?
Yes, ma'am.
Do you get tired of listening to that?
I sure do.
I'm wondering what texts are getting in return and emails and stuff.
At this point, I'm fucking sick of these stupid fucking games you're both playing. You cannot replace me with some fucking dipshit who just walks in and acts like a pretend daddy. You're a pathetic excuse for a mother or a parent.
That's a good title. Thank you, Erica. That's a good title for this clip.
I hope your fucking arteries clog up.
And this was after rehab, mind you.
This is what?
After rehab, when he was supposedly sober.
Right.
Hence why you should
I
never...
refuse to pretend to be nice to you anymore. And he's not, is he?
No.
Does he have family in this area?
Not in Dixon, but his family lives in Stewart County.
Okay. You offered to let him come any weekend and visit with the kids?
Have I offered?
I mean, if he's asked, has he?
Yeah. I have this notion here that all of these texts came after she denied him time with the children. So, yeah, toxic parents and the kids are getting in between. this is just my notion. If you believe her wholeheartedly, I don't blame you. If you believe him wholeheartedly, I don't blame you either. For me, it sounds like two people who should never have met.
If you would, just go and explain to the court how many times that he's called and asked for them since we filed this petition in July of 2020.
So he asked for 4th of July, that he refused to sign the order. His wife asked for March. I never spoke with him about it.
Did you hear how she said his wife? The tone there.
And his random phone call, or
Hey,
Christmas.
the
and then his
Maniac
last random
Smith.
phone call.
The 4 occasions.
Yeah, I haven't
including
seen you in a good
Correct.
while. How are you
when
doing?
he came one time.
Yes.
I hope you're
Has he
doing
ever
well.
offered to
I
come
hope
down
you're
here and
doing well
visit
too.
time with- spend
No.
time with them?
No.
I'm doing well.
What was the plan for this last Christmas? Even though he said he hadn't seen the kids in a couple of years, and he recanted when he got on the witness stand and said he did see them.
So he called and said he was in town for Christmas, obviously with his family. This was actually in July, or January, not December. Said that they were all in town doing Christmas with his parents. His parents got it to get the kids stuff for Christmas. They got stuff for Christmas. Can we swing by and bring it? I was like, well, we're gonna be going to Jacob. I believe Jacob had something going on. Oh, his wrestling ceremony. I said, well, we've got a place to be,
Christmas?
but you can swing by and
Your oldest child had a
yes.
school event.
Yes. I said, you're more than welcome to come by, bring the kids their gifts, hang out for a while till we got to go. They showed up, stayed maybe 30 minutes and left.
Kids enjoy seeing him?
They did.
Do you want to establish a parenting plan to give him an opportunity to get reacquainted with these kids?
Yes.
You want him to make the effort to come and to visit?
Yes.
We have filed a parenting plan with the
I
court
don't
stating that he can
think
come down
that was
here,
correct. That was
any
truthful.
weekend upon 30 days notice and have him for the weekend.
Yes, ma'am.
And he has a place to stay with family
As far as I know, his mother or his grandparents.
and they live in Stewart County.
His grandparents live in Clarksville. His parents live in Dover. Yes.
And so you don't have a problem with him keeping them for a weekend?
No.
But during that time, if they have an extracurricular activity, if Raiden is playing football, if he comes down in the fall, you want him to be required to carry him?
Yes.
Correct? And you think that would be appropriate for him to start that residential time to get reacclimated and back with the kids?
Yes, ma'am.
Additionally, you've offered him 1 week in June and 1 week in July.
Correct.
Is that correct? And you're still willing to let him have that this summer?
Yes.
We're here, we are at the end of May, so he could have time with them for the summer.
Mhm.
Are there activities that have already been planned for the,
Raiden and Renoa do have vacation Bible school, June 10th through the 12th.
and then do you have a family vacation planned?
Not this summer, no.
So again, him pick a week in June and other than when they're going their vacation Bible school.
Mm.
And when does the football program start for Raiden?
The end of July.
The end of July.
Yes.
So anytime before the first couple of 3 weeks of July.
Yes, and Renoa's 5th birthday party is July 19th.
So you already have a party planned and paid for.
Yes.
So the 19th is not a week. that he can have
Correct.
to go. Is that correct?
Yes.
Do you want to have you made the decisions about the kids? As far as going, who signed them up for school?
I did.
Has he, to your knowledge, has he reached out to the school and signed up for any type of Charlotte? Do they use Classroom Dojo?
They
or
do use
Skyward?
Class Dojo and Skyward.
And Skyward. And those are both available to be signed up for,
Yes.
correct? And the instructions for that are on the website with the Dixie County Board of Education,
Correct.
To your knowledge, has he signed up for any of that information?
No, ma'am.
Who carries them to the doctor?
I do.
Are they covered under TennCare?
Yes, ma'am.
Has he offered to pay any insurance or anything from that standpoint?
No.
Money's always been a tool that he uses.
Y-
against you,
yes.
correct? Who's provided for food and clothing and housing and all of their activities?
Josh and I.
Okay, and carried them to school, picked them up, paid lunch money, done the day-to-day drudgery of being a parent, not the fun stuff, but the work part of it. Who's done that?
I do.
Has he reached out and asked and said, how are the kids' grades doing? What are they involved in?
No.
And if you reach out to him, are these just some samples of how you're responded to?
Yes, ma'am.
And we have stacks and stacks that we could go through. They're all consistent.
Yes, ma'am.
correct?
Yes,
You want to be able to make the decisions without being called a cunt, don't you?
absolutely.
This is why he should have retained an attorney for this hearing, because it's hard to. Now, this is just generally because if he actually can afford to be back on child support, he should be able to at least the same attorney who was there for the mediation to be here on this hearing, because things aren't going good for him. not on the, but if you just go by the words alone, things aren't looking swell for this guy.
Holidays. If he picks a weekend that's a Monday holiday and gives you sufficient notice, do you have a problem with his one weekend a month to be extended holiday?
No, I do not.
You're just asking for notice
Yes, ma'am.
and consistency.
Absolutely.
Are you concerned about his drinking?
I am.
Concerned about his temper?
I am.
Are you concerned that he's going to try to speak badly about you and try to use the kids as a pawn against you, like he's used money as a pawn against you?
Yes, ma'am.
Has he offered, I mean, is any concern whatsoever about whether the kids are being fed and clothed and have adequate
No, he's
nutrition
not.
and things like that?
No, he is not.
Other than calling you these nasty and ugly names repeatedly? You offered any assistance in helping rear these kids?
No.
Gripes about your fiance?
Yes.
But again, he married just a few weeks after y'all separated, correct?
Correct.
And did you know his wife?
I did not.
Have you met her other than,
Until they got married. No, ma'am.
and have you met her since then?
Yes.
Have any issues with her?
No, ma'am. Other than she will like to send nasty grams too. Every once in a while, she'll get in her feelings and send me a nasty gram, and I just don't say anything. And
This is between you and him. You're the parent.
correct.
And you think the parenting plan that we proposed is appropriate given the circumstances?
Yes, ma'am.
That's all. Now he's going to ask you some questions, okay?
Well, if you're representing yourself, this is not your chance to make statements. It's your chance to ask questions. If you want to, you're not required to. Do you want to ask her any questions? All right, thank you, ma'am. You may step down. Robert, you may call your next witness. Good. Petitioner has rested their proof, so Mr. Wambier, do you wish to testify or offer any other proof?
Yeah, he wishes he had retained an attorney for this.
I was taking those moments as a reflective period. A lot of what she read out, that was very true. I said some nasty, heinous things. I didn't do right. I'm willing to accept the proposal that they've given so that we can end.
All right,
end
Mr.
this.
Roberts, it appears he's willing to accept your proposal. So if you will submit your proposal in written form, then we will go from there. Thank you, Mr. Wambier. If you will wait around, you'll just confirm that, just have a seat for a second.
Yeah. Oh, this is interesting because this is far more than he already had, than he had for the past year and a half. Far more. Now, yes, he sounds reasonable in court. We don't know how he acts outside of court. We know how she sounds in court. We don't know if there are different triggering moments. We don't know. Did he get married a few weeks after they separated? Yeah, maybe weeks after he moved out. Yeah, it's really strange. And still, I mean, a year and a half later, she has a fiance that she apparently is trying, well, apparently I say, in my interpretation, more or less is telling the kids, this is my interpretation, she's more or less saying this is your new dad. And now this proposal, it sounds like a proposal they were hoping that he would reject, because it's far less than he actually asked for. But boom, he accepted it. So, but it's so, I hate it when kids get in between fighting parents. Yeah, there is certainly more to this story. Certainly more to this story. But this will be a clip on my Child Watch Clips channel. I will
I have
edit
his
out
address
the
and
names of
and his email address. He's provided that to me previously. So I will just do an order adopting our parenting plan and send that to him.
Make sure that reflects that he announced in open court that after hearing the testimony, he would agree to it. Let me just talk to the two of you for just a second. Ms. Roberts has heard me talk about this for some time. I understand why you might have animosity towards her and you feel like you're being cut out of your children's lives. It is your obligation to pay child support, whether you get to see your children or not. It is her obligation to allow you to have a visitation with the children, whether you're paying or not. And what I would remind you both is that the interest that you need to be putting first is not your interest or his interest or your interest. It is the children's best interest. And so for that reason, I understand in that fit of anger, hostility, things get said in text messages and otherwise. But in my opinion, there's no excuse for the fact that you would use that kind of language towards the mother of your children. You need to think about the fact that in today's society, things like that become permanent. You can think you can delete them, but you can't necessarily. And as a result, if you want your children to grow up knowing that that's how you talk about their mother, then you've done a pretty good job as a start. So you need to do that. And this order that I'm going to put down, it not only accepts Ms. Roberts' proposal, but it's also going to include my order that there will be no derogatory remarks made by you towards her, period. And I don't care if it's in a text message, telephone call, or whatever. We're going to cut that out. Same thing goes with anyone else. Your wife is not I don't know your wife, but your wife is not a part of this action. But I'm ordering that there be no derogatory remarks made. When you have this visitation, and you're going to have the children go with you, as they've set out, that you're going to have a week in the summer and so forth. Those things, when they happen, you're going to have them away from their mother. There's a temptation to try to justify yourself and to talk badly about their mother. Don't do that. Don't do that to your children, for one thing. Your children need to love both of you. They don't need to hear one of you downgrade the other one or make derogatory remarks. So I'm putting in this order that there'll be no derogatory remarks made to each other, and there'll be no derogatory remarks made to the children. That is the main thing. The other thing is obviously, I applaud you if you have gotten your sobriety, and I'm just going to say that when the children are with you, there'll be no alcohol in you or on you, as I say. You don't have alcohol in your home when the children are there exercising their visitation. And pardon? No, I'm not going to exclude the fact that there'll be no alcohol at all. You've got family around. You don't consume it, and you just don't need to let your children see you. And obviously, if there's an issue, it has a way of bubbling up and surfacing if there's another problem. I trust you that you say you've gotten sobriety, and I'm going to give you that opportunity to see the children. But I want the order to reflect that you're not to consume alcohol while the children are with you. Okay, all right. And that's pretty much what I wanted to say, with the exception of the fact that I understand as well from you, Ms. Whitworth, the natural animosity you have towards somebody that might talk to you like that, the natural animosity of someone that you might have towards somebody who hasn't paid child support. He'll pay a price for that in juvenile court. But what I think your job is going to be is to try to make sure that you don't let your personal feelings about how he's talked to you or what his attitude has been prevent you from being able to encourage him to have a good relationship or encourage the children to have a good relationship with him. That's going to be your job from here on out, because if you believe your children need to have both parents, then this is your opportunity to encourage them to go see their father, spend time with him, and make it something that they look forward to rather than the fact that they don't. So both of you try to put your children's best interest first, and hopefully you can work through this without any further problems. But we're not going to have any more of this language that's being used. And there really shouldn't be any anger or animosity. Try to reason with each other without being angry, and I think you'll find that it goes a lot further. If you will extend the olive branch to each other, then I think you can do that. You also need to get involved with your children's school by if there's a parent portal that you can get into to be aware of what's going on with your kids, and do that. And then, if you want to see your kids and he wants to show up down here, I understand you say, well, it might not be convenient. One of the things that bothered me about your testimony, I'll tell you, he said, I'm an hour and a half away, and he wanted to come by and see the kids. And you decided that was not the best thing for your kids. Let him come by. There's no reason in the world, an hour and a half away, and he comes by for 30 or 40 minutes, they get to see their father. By denying that, you are preventing them from having an opportunity to interact with their father. And then you complain because he's not been around. So what I want you to understand is, if he has an opportunity to come by, let him come by, let him see the children. We used to have, one of our judges used to tell the mothers in cases, I didn't necessarily agree with it, let him see the children as often as he wants to, and he'll get tired of it soon. Was that judge's attitude. I don't think that's true, but it was good advice to let him see him. If he's in the area, he calls you up and says, hey, I'm going to be around because I've got a job or I've got something else. Let him see the kids. Don't deny him that opportunity. Denying him the opportunity does one thing. It prevents him from being able to see the children, but it does another thing. It reflects badly upon you as a parent, because you're not protecting your children like you think you are. You are hurting him. And I understand why you might have felt that way. But from here on out, we're going to let him see the kids whenever he's able to be around. Now, by the same token, you can't just, call up every other day and say, hey, I'm in the area, I want to come by and see. It has to be reasonable. So both of you use common sense and be reasonable with each other. I think you both love your children. You just have to get past this animosity that's developed, and hopefully you can co-parent your children. Ms. Roberts will draw the order.
Yes, Your Honor.
Thank you.
If I could have a minute before we start the next one, if I can
All right.
excuse the ladies.
You may.
Okay. Yeah, this will definitely, I will edit out the kids' names, but this will be with the judge's speech afterwards, how they acted on the stand. Yeah, this will be a separate clip on the channel. It will be a half hour, almost 40-minute clip. Remember, I'm playing this in 1.25. Maybe I should still do the clip in 1.25 because it was really clear language from both of them.
All right, I'm going to step off. I'll be right back in just a few moments.
All right, next on to the next case. And he's back.
Tomorrow morning.
Earlier, Judge, procedure question. As I was saying earlier, I started this petition by simply filing a petition to modify child support. Then he has, through his counsel, Ms. Hendrickson has filed a petition to modify the parenting plan. From a logistics standpoint, my petition to modify child support is going to be factored into the
Obviously, I
modification
need
of
to hear the
custody.
petition to modify the parenting plan to determine how many days each one of them has to determine the child support.
So after that, I filed a petition for contempt. So it just seemed, counsel and I were talking, Ms. Hendrickson and I were talking about the fact that it seems just putting my client up and saying this is your income and then calling her back down and me calling him on the petition seems a little bit far-fetched in the fact that he should move on his petition because mine is encompassed in
Right.
the request for modification.
Well,
If the
then,
courts
it seems to me
agree.
we hear the petition to modify the parenting plan first, and then we'll do the child support issue. So, Ms. Hendrickson, does either side wish to make an opening statement?
Good morning, Judge.
Okay. First of all, Jacob's Proud Madre. $5 super secure. That is so nice. It is a game controller with a hurt arm. Thank you. That is so nice of you. This is just a stream where I show how I collect clips to my Trial Watch Clips channel. But you started to show up, so it became a stream instead. This is technically my day off. So you're joining me on my day off. And my day off is collecting clips. And I will do another hour with you guys. And because then it's dinner time. I have pig cutlets in gravy and ankle chili being slow cooked. And it will be done in about an hour. So we will be doing this. We're checking in with Judge Wolf here. And yeah. Just so you get a notion, this is how I select the clips. I actually watch. And after dinner, now that won't be streamed, but usually I do this in 2-point speed. I will see within the first minute, is this something I want to cover or take a clip from? If I'm not, I'm just skipping over to the next, and then the next, and then the next. But now, since you all are here, we are just watching Judge Wolf. On my day off. Yay. And thank you again, Jacob's Proud Madre. And oh, please, on the top of the chat on my main channel, you will see a link that is to the Trial Watch Clips channel. So I'm streaming this there as well. So if you wouldn't mind, please jump over there, watch 10 or so minutes, hit the like button, hit the subscribe button, and once this stream is over, you can select one of the playlists. I have George Boyd, I have George Simpson, I have. Let me just check here, so I'm not. Dun dun dun. I have George Boyd, George Simpson, I have George Middleton, I have Karen Reed trial, I have a few clips from the YSL trial. George McBurney, And I have my YSL trial songs on there as well, if you want to relive those. So, but it's recently started, so it's not heavy with clips yet, but it will be eventually. So if you wouldn't mind to just pop over there. Thank you. Okay, let's see what this next case was.
Good morning, Judge.
Good morning.
In this matter, I represent the father, Mr. Jones. As was mentioned earlier, this started in a petition to modify the child support, and we did file in an answer to that in a counter petition to modify just only the residential schedule. So we're not asking to modify the designation of the permanent primary residential parent, nor the decision-making. And I did file, just I believe yesterday, a revised proposed parenting plan because there was an error in our first proposed parenting plan. We did not mean to request to change the decision-making of the parties. And so I would just like to begin, Judge, by saying that the parties here is in no way similar to the first parties. The parties are actually
What you were saying is that the situation here is not like the last one.
there's no animosity much in the parties here. I actually commend the parties because they really work together, just looking at their text messaging, that's how they communicate primarily. There are some instances, very isolated instances where my client had sent a not so good message to the parent, Mrs. Maples, but those are isolated. And I would say or submit to the court that within the past year or within even this year, they have been managing their co-parenting really well, to the point of even through the litigation, they have managed to agree on the Memorial Day weekend residential schedule and things of that nature. And so what we're want to bring to the court's attention is that there has been a material change in circumstances for the purpose of changing the residential schedule. Just among other things, majorly, my client is now working only 4 days a week instead of the 5 days a week. So that enabled him to spend more time. And he had made a conscious decision in the past 2 years to spend more time with the child. The child is now going to school the past 2 years. He was about 2 years old when the parenting plan was established in 2017. So he started school, finished two years now. So his developmental needs have changed over time. Both parties are now married. Their respective spouses are very supportive of their co-parenting, which is great. Mrs. Maples have a child with Mr. Maples. My client's wife, Kristen, is with child. She's expecting in a couple of months here, and you will hear from her hopefully today to testify. Mrs. Jones has an 11-year-old son. She is very close to the minor child that is the subject of this matter. And the minor child right now is 7 years old, I believe. His name is Brett. And also we would submit that the parties some 2 years ago, back in June or July of 2023, agreed. The conversation was initiated by my client. He requested for more time. And in fact, he was represented by Ms. Smith and they were trying to do mediation, but just didn't come to fruition. But however, via text, the parties talked about it. And Mrs. Maples, out of the abundance of her kindness, offered Thursday to Tuesday. So instead of the original Friday to Sunday, which is 2 nights every other week, my client has been getting the child Thursday to Tuesday every other week, 5 days. In the original parenting plan, the father also may get the child Mondays and Tuesdays after school and return to Mrs. Maples when she gets out at 7:30 p.m. That is not the case anymore. And even in Ms. Maples' words in her text, that doesn't work. And I believe that she also has a different work schedule. I believe she works for the school now. So her schedule is Monday to Friday, and she gets out earlier than 7:30. So that's not workable anymore. So Judge, because it's a request for a modification of residential schedule, as you know, it's a lower thresholds, but preponderance of the evidence. The case Ambrister versus Ambrister, the Supreme Court case, which I'm sure you are aware of that case, did provide the trial courts with analysis of how you go about determining whether there's a material change in circumstances. And it would include if it affects the welfare of the child, foreseeable circumstances, such as going to school, getting older, having different developmental needs. And so in this case, we submit that all of these changes does affect Rhett's welfare in a meaningful way. And as it relates to the change in or modification of the child support, it would be inequitable for my client to continue, and Mrs. Maples is agreeable to continue the Thursday to Tuesday, but my client not have credit for that in the child support worksheet. And he has been providing financially when he has the child. So Mrs. Maples is not giving him, and rightfully so, because Mr. Jones, my client, is he's amenable to providing for his son. And he's gone above, over and beyond what the child support order was. He's been providing for extra needs for this child, and that will be shown in the proof. Thank you, Judge.
Ms. Roberts?
Your Honor, again, my client changed jobs, he changed jobs. She had a afterborn child. He now is expecting an afterborn child. So originally we filed just to modify the child support. If I could, Your Honor, back on May 7th of 2020, the existing parenting plan was filed with this court. Both parties were represented at the time, and of course, Ms. Willie was designated as the primary residential parent. The father was afforded residential time with the child every other weekend from Friday at 6 until Sunday at 6. And additionally, he could pick up the child from daycare on Monday and Tuesday and keep the child till 7:30 because my client's work schedule was such that she worked on those days and he was able to pick the child up at daycare. The parties, again, mutually agreed that he could have the child from Thursday afternoon until Tuesday because it just merged that schedule together. His work schedule changed, her work schedule changed. That is what the
This
child
won't
is
be
used
a
to.
quick-
That's what the child has done.
But
and
it's
that's our
interesting to listen
proposal
to.
as
Hi,
far
Derek.
as
Hi, Derek.
adapting to this child. There is no basis just to go and just do a 50-50 just because he wants it.
You're agreeable to keeping the Thursday through Tuesday.
Yes, Your Honor, every other weekend. So he has the child 10 days.
He has it 5 days in a row, 10 days out of the month.
Yes, sir. And that's what the parties have been doing. They both stipulated and agreed to that without the necessity of a court order
Which I think is commendable.
to extend the father's time so he can have blocks of time with the child. This is consistent with his work schedule and consistent. The child is now in school going to Van Leer. That's where my client resides. She works at the school system and she works at Burns, but the child had started school there and his friends and his associations are there. And again, we have no problem in adapting what was established by the court or not what was established by the court, but what the parties agreed to as was in their child's best interest. And then just to come up and say, hey, because we agreed to just encapsulate the time instead of doing a Monday and Tuesday where you just get from after school, spend the night with it. That's just not a basis to come up and say, because you agreed to a modification, now we want more. The consistency of the child in school, both families that the child experiences with, the consistency that the child has had, and that this schedule has worked. And that's where we think that the court should just adopt that schedule, take the party's income. And again, so what we're going to be doing is we filed this petition. So you've got a modification from the date that we filed. My client then in August, after she filed the petition in August, she had her afterborn child. So the modification from the date of the filing until her afterborn child was born, then she has a credit for an afterborn child. And that will be the number of days based on what he has now up and until a time when he has an afterborn child, which I think is I was inquiring, but I think his child is due in July. Is that correct? So in July, there would be a further modification whenever that child comes into effect. Then, Your Honor, we do have an issue of a contempt that we filed because the father during his residential time had the child baptized and they're supposed to make joint decisions with the mother having it. Religion is one of the factors, and the court, I'm sure, is well aware of the factors that and the court decisions that have been set down, especially on baptism when it's supposed to be a joint decision making, and he did not include the mother in that.
Right, well, we're shortly before noon, so we'll take our noon recess now, and we'll attempt to resume shortly after 1 o'clock. One thing, I'm happy to hear that the parties have been working together so well in the past. And unfortunately, sometimes these kinds of cases, the litigation and the actual trial can create more animosity and can destroy the cooperation that has existed up to this point. So hopefully that will not happen, but we'll give you an opportunity to present whatever proof you want when we resume. We'll shoot for 1 o'clock.
Thank you. Okay. I'll get you some lunch. Be back up.
All right.
I'll come back
So
over.
now it is
Okay.
a break in the
I got down
proceedings.
to, juvenile court.
Now, what I'm going to do is I'm going to send you all over to the Trial Watch Clips channel because, frankly, I need the watch hours and I want you to subscribe over there to that channel so it gets closer to monetization and such. So, if you want to, you have the link on the top of the chat. Otherwise, I'm closing down this stream on my main channel, and for the final 40 minutes, it's going to be just a stream on the Trial Watch Clips channel. Just so you're forewarned. Just so you're forewarned here. So I'm going to. So yeah, look at the top of the chat, the pinned on my main channel, and and I will close down the main channel stream in 3, 2, 1. I have no. Oh, for fuck's sake. Folks, I'm stupid. I forgot to press enter on redirect. Hey, Precocint. Yeah, I messed up. I forgot to press enter on the redirect from main channel to Clips channel. It's my day off. Oh. Yeah, if well, some of you found your way over. Some of you find your way over. Hey, I'm here and subscribed. Hello. Hello again. Of course I boomered. Of course I boomered. Oh. Well, not a stream without a boomer moment. Not a stream without a boomer moment. Oh, God. Yeah, all right.
So I'll reach out to Mr. Walker.
All right. Let's get back to Judge Wolf. Let's get back to Judge Wolf. Yeah. I will do a similar stream next Sunday. And yeah. Oh, well. Nothing. I can't do anything about it now. So. Everything lined up except pressing enter on save.
Over the lunch hour, I had a conversation. You ruled on the Knopfsinger case. It was the
Yes.
California matter. And they had the hearing today.
Okay.
And the California judge dismissed the petition in California. At 1:30 on Friday, your order was entered and it said, my motions for temporary financial
I
support
can see that a
were
bunch.
continued, and
At
you
least
said
5
at
of
1:30
you
for a status
followed
conference.
over.
Yeah,
so
that was just to determine whether or not the California court.
That's what I wanted to clarify, because my motions aren't set for Friday. It was just a status conference.
And really, if that is the case, then self-apparent that we now have jurisdiction.
I just wanted to make sure that, because I'll reach out to Mr. Walker when it, right, because he had something in the morning and I think he was going to appear via Zoom or whatever. So I just wanted to make sure that you were aware. I don't know what else.
But I appreciate.
Well, I just found out over the lunch hour. So I wanted to make sure you knew that I should have an order. And so there should be no need for that status conference, and we'll just have to agree on resetting my motions.
What?
Okay.
That sounds fine. Did you hear all of that, Madam Clerk? The Knopfsinger hearing at 1:30 on Friday is off. Yeah, is that supposed to hurt my feelings? All right, Ms. Hendrickson.
Yes, Judge, I'll call my client
All
instead.
right, Mr. Jones, if you'll come forward, please.
Mr. Jones, state your name for the record, please.
Gregory Kyle Jones.
Okay. And you have a minor child with Mrs. Maples.
I do.
And what is his name?
William Ritt Jones.
How old is he?
He's 7.
7 years old. And your current parenting plan, that was established in May 7 of 2020, correct?
Yes, ma'am.
And he was what, 2 years old at the time?
2.5.
2.5 years old. Okay. And what was your marital status at the time the parenting plan was established?
I was not married at the time.
Okay. And neither was Mrs. Maples now, correct? She was not married at the time?
Correct.
Okay. And since then, have you been married?
Yes, ma'am.
And you're married to Miss Kristen Jones, correct?
Yes, ma'am.
And is she's with child right now? Is that correct?
Absolutely, yes.
And when is her due date?
The end of July.
End of July,
Mhm.
okay. Do you know what is it a babe, a girl or a boy, or is that a
It'll
secret?
be a little girl.
A little girl,
Yeah.
okay. Okay, and then so Mrs. Maples has since been married too, is that right?
Yes,
Okay, and she has a baby
correct.
with Mr. Maples, is
Right.
that correct? Do you know how old her child
I'm
is?
not.
You don't
I
know?
don't know for sure.
Okay. All right, so who currently reside in your household?
So you just have myself, my wife Kristen, my stepson Noah. He's actually 12 now.
Okay.
And then Rhett is with us the 5 days.
Okay, so your wife Kristen has her son Noah, and Noah's how old now again?
12.
12 years
Mhm.
old. And what is Kristen's residential schedule with Noah?
We have him all week. He goes to his dad's every other weekend, Friday
Every
and
other
Sunday.
weekend. Okay.
And then there's a lot of exceptions where they work it out and he goes to spend extra time with his dad.
Okay. All right. And so where were you employed at the time the parenting plan was established?
I'm wanting to say I was at Material Handling Inc.
Okay. And what was your schedule at the time?
I was working 5 days a week,
Okay. From
typically 7 to 4.
okay. And did that change at some point?
Yes.
Okay. And so what did it change to?
So then I had swapped to Toyota Material Handling Inc. And then in the spring of 2022, they adopted the 4 days. We work 4 10s and then it's a
Okay.
rotating day. So let's just say this week I'm off Monday, next week I'm off Tuesday.
Okay.
It just keeps going.
Okay. And from what time to what time is your shift there?
It's pretty flexible. It's whenever you start, that's when you start your 10 hours.
Okay. Like for example, the other day, did you work yesterday? or
Most of the time
other
I'm
day?
working 6 to 4:30.
6 to
That's
4:30.
typical.
That's your typical
Yes,
time.
ma'am.
Okay. And how many hours a week do you typically put in?
40. I mean, I don't get a lot of overtime. I
Okay.
have gotten some overtime here recently because I've been doing some extra training just to try to further my education in what I'm doing.
Okay. And we provided Ms. Roberts with your income information. So I'm gonna go ahead and show you this.
Thank you.
You can tell me what those are?
Yeah, this is last year's W-2 and then a statement for May 2nd, which would be a 2-week pay
2-week
stub.
period of this year, correct?
Yes, ma'am.
Okay, so for your W-2 2024, does it state that your gross income, and I'm looking at with the social security wages, it was $61,091.49?
Yes, ma'am.
Okay, 61,000, yes. Okay, and then for your pay stub for May, that was a pay date of May 2, this is a 2-week period?
Yes.
Okay, and your hourly rate, it states 39.95? Is that right?
No, regular is 33.
I'm sorry, 33.95.
Yes, ma'am.
Yeah, I misread that. And in this pay period, you put in about 77 hours plus 1 hour of overtime,
Yes.
correct? Okay. And so your gross income on this is $2,962
Yes. Yes,
and
ma'am.
14 cents.
Yes.
Your Honor, I would like to enter that as an exhibit.
Mark it as Exhibit 1.
For the May pay stub, $2,962.14. Gross pay on the left side. Okay. So, Mr. Jones, in your current parenting plan, tell us how many days Mrs. Maples was assigned, and then how many days for you?
I'd have to do the math, but specifically in the parenting plan, it states that I get my son every other weekend
Okay.
from Friday to Sunday.
So that's 275 days for her and 90 days for you.
Right.
Sound right? Okay.
Right.
So you get Rhett under that parenting plan every other weekend, Friday to Sunday, correct? Okay. And then there's a stipulation there that Monday and Tuesday you may also get him after school, and then return to Mrs. Maples at 7:30 p.m. Is that correct?
That would have been the current.
In the
yes,
current,
yes,
okay.
ma'am.
And so, what is the current schedule now?
So since July of 23, we have right before he established school, I initiated a conversation about going ahead and seeing about getting my son more. And she agreed that we would do every other Thursday to the following Tuesday. So I pick him up from school Thursday, I take him to school, pick him up Friday, have the weekend, take him to school, pick him up Monday, and then take him to school Tuesday, to which she picks him up from school.
And so, so you have been doing that for about 2 years now, is
Yes,
that
ma'am.
right?
Yes, ma'am.
And how has that affected Brett? Has he adjusted to
Oh,
that
he
schedule?
adjusted very well. He knows when I'm picking him up. He knows when he's going to his mother's. I mean, he's done very well.
And so because you testify that your work schedule has changed, how does that affect the time that you spend with Brett?
So in the summer, the days that I do have off that I have him is great because we just get that whole day together. And then usually me and him and Rhett, or me and him and Noah are usually going and doing some kind of outdoor activity of some sort. So it's been
What about
great.
during the school time? Are you able to spend more time with him?
Yeah, I get to take him to school and then pick him up, and he loves it when I'm the first one in line. So when I'm off, I can be the first one in line.
Okay.
And then we just have that whole evening to spend together.
And so right now, I mean, it appears that Mrs. Maples is agreeable to the Thursday to Tuesday.
Right.
But we're asking if the court will allow you to have a 50-50 type situation where it's
Yes,
a
ma'am.
Sunday to Sunday or Friday to Friday,
Yes, ma'am.
whichever. So would your schedule allow for that?
Absolutely.
Okay. And do you have the willingness to take on more parenting responsibilities if given the opportunity?
More than willing. Yes, ma'am.
Tell the court, Rhett has, he's 6 years old now. So has he gotten into different types of activities that he's able to do with you?
Yes, ma'am. And he's 7 again. But
7 years
yeah.
old, I'm sorry. He was 6 during this.
Yes.
Yeah.
He recently got into soccer. So when he was with me, I don't know anything about soccer, but I definitely tried to learn some stuff, just to be able to spend time with him. I make all the soccer games, as many practices as I can. Baseball, I coached his baseball team multiple years. I mean, we just do everything. He's right here with me all the time. Like, we're always together.
Okay. In terms of the day-to-day needs for Rhett, tell the court what is your participation in that during your parenting time?
I'll just make sure that he's got everything he needs. We play, make sure he's eating good. Anytime he's eating something new, I always send that to his mother because we just try to make sure that he's eating healthier.
Okay.
And he's really picky. So when he eats something new, we make sure to let each other know.
All right. Speaking of your communication with Mrs. Maples, describe how is the communication between you and Mrs. Maples progress? It's been 5 years now since
Yes,
that parenting plan was established.
I mean, sometimes it can be a little tricky, but I mean, for the most part, it's really good. Usually, if I need him for a day that I have something planned that I know he'd like to be a part of, I communicate that to her, and she'll usually accommodate that, and we'll swap some days around, or vice versa. For the most part, it's really good. And then up until now, I mean, it's been really good in the past few years. So
Okay. Had there been communications where there was some conflict between the two of you?
yes, ma'am.
Okay. So I'm going to show you. Can you, do you recognize that text messaging?
Yes, ma'am.
And who are in that text messaging? Between,
So this was when she decided to move right to the different ballpark. This would be me and her texting back and forth.
so it's between you and Mrs. Maples?
Yes.
Do you remember when this was?
This was last spring.
Last spring of 2024? Okay. And so just give us an idea of what, what's going on with this text messaging.
So Rhett had decided to play T-ball first year, and I had been coaching for numerous years at Buckner Park in Dixon. I was going to coach him again, just as before, and it just all of a sudden he signed up in Charlotte, and this was I was asked to be a coach, so in that usually you get your own child as a coach.
Okay.
But another guy was there and said that he was keeping him, and then it just kind of got into an argument because Aaron, which was the other coach, told me that he would have to check with the mother.
Well, I don't know if it's actual hearsay unless it's being introduced to prove the truth of the matter. What's the purpose of introducing a statement?
Just to explain why he sent a message that's, it's not very savory, but we're trying to give a background of the text message that my client sent.
Avoid quoting. You can't quote what somebody else says. You can explain why you did a certain thing. I am of the opinion that, at least I don't know whether it's actual hearsay unless the purpose for which it's introduced, but I'll sustain the objection at the moment.
Let me ask you a different question.
Sure.
So would you agree that this text message that you sent Mrs. Maples, was that an appropriate text that you sent to her?
No, I mean, it wasn't very tasteful, but I mean, I've learned from then, and I'm doing a lot better now. I mean,
And to be clear, this was sent to her in the spring of 2024, is that right?
yes.
And you basically told her here, I'll just rephrase, Judge.
Sustained.
Okay, so after this text message that you sent, was there any other messages that you sent to her that's, a little unsavory or, just using language that should not have been used?
Yes.
Judge, I would like to enter that as an exhibit. Okay, so do you recognize that text messaging?
Yes, ma'am.
And who are the participants in that text
Um,
messaging?
Me and Miss Maples.
Okay, and then so this text messaging, can you explain what's going on in this text messaging?
Yes, ma'am. I actually help a friend of mine. We manage some property that he owns. I happened to be out there that day. It's about 5 minutes from the school. His wife was going to pick up their children from the school, and I was just asking Miss Maples if I could have Kimmy pick my son up from school. It was my day to have him and just bring him to where I was.
Okay, who is Kimi?
That is my friend Justin. It's his wife.
Okay, and you didn't give me a date on this. When did this text occur?
It would have been last year.
Okay,
was
was
in
it
kindergarten.
around the springtime, I think?
Yeah.
Around May of
Yeah, because we were
2024?
planting crops while we were
Okay.
in.
All right, and then so you had a little bit of a back and forth between you and Mrs. Maples, is that right?
Yes, ma'am.
Okay. As far as you know, have there been any other text messaging between you and her, aside from these two here regarding the coaching and the pickup situation,
The only thing that comes to mind for me is the issue with the baptism.
the baptism? Judge, I would like to enter that as an exhibit. Let me ask you this, those two text messaging that we entered, does that in any way show how your communication had been in the past 5 years?
Yeah, I mean, like I said, it was a little bumpy, but it's very few instances.
And so it does not, it does not portray the overall
No.
characterization of your communication.
No.
Well, how would you describe your communication?
I would say our communication is, I mean, if you had to put it in a percentage, 98% great and 2% need to work on.
All right, you mentioned the baptism, so let's talk about that. When was your son, when was he baptized?
I don't even remember that date right off the top of my head.
Was it last year?
Yes,
Back in August?
Yes.
Does that make good? Okay. So tell the court, was that a pre-planned event
No,
for your
ma'am.
son?
No.
Okay. Were there any conversations that were be had before then?
So we had been talking about filling up the baptism, like the baptism pool. And it was just an overheard conversation between my in-laws, which are the pastors at the church. And then Rhett just overheard it and asked me that night, hey, what does being baptized mean? The boy just believes in God. That was the only thing that we knew, was that they might be doing some baptisms.
Okay. So that conversation, was there anything about you having knowledge that your son was going to get baptized
Not
the
at all.
following day?
Not at all.
Okay. So then let's go so the following day, Sunday,
Right.
you all went to church, and who was with you?
So my wife was with me, my stepson Noah, and Rhett.
Okay. And then so tell the court what happened then.
So we just had a regular service, and then all of a sudden it was just an altar call. That anybody that wanted to be baptized, they could come on down and be baptized. Noah decided he wanted to do it, and then Rhett looked up at me and said, "Daddy, can I be baptized today?" And I said, "Son, that's between you and God. It's not between me. It's and you." And that was it. He just went with them. I didn't get baptized that day. My wife didn't get baptized that day. That was just it. That's what happened.
Well, had you known that was going to happen, who would you have invited?
Had I known, my
Yeah.
mother, just like she's here today.
And who else?
I would have invited her. I would have at least let her know that our church doors are open.
Okay. And there was a text message that was okay, so you testified that had you known, you would have told the mother about this.
Right.
Sustained.
Do you recognize that text messaging?
Yes, ma'am.
Okay. So who sent the it looks like a video in there. Who sent that?
Right. So I that was all the time I had to do. I took a video of it so that she could at least see it.
Okay. And explain to the court, so you texted, will you read your message to Mrs. Maples there?
Our boy decided to accept Jesus as his Lord and Savior today. Just wanted you to know. We talked about it last night, and he wanted to get baptized.
Okay. What did you mean when you said we talked about it last night
That
and he
was-
wanted to get
Right.
baptized?
That was me explaining to him what baptizing meant.
Okay.
Then he wanted to get baptized was meant as he wanted to get baptized. Like, he just sporadically asked me that day if he could be baptized.
On that's what day?
The day of that Sunday, the day.
I'm not entirely sure how spontaneous that was. Now, personally, I mean, I don't mind if kids want to be baptized or parents baptizing their kids into their own religion. But if there is an argument about what religion, or at least what kind of church they want to go in these matters, both parents should be with it. It should be a joint decision, in my opinion. You just don't take off and baptize your kids into your own church if the other parent is of another church. It has to be a joint decision.
Of the altar call.
Okay. And then so read the next messages there.
So she says that she would have loved an invite to that. And I said, well, I didn't know, so that's my fault. I figured y'all had a church.
Okay. So what did you mean by that when you said, I figured you all had a church?
That if she wanted him to be baptized at her church, I had no problem with that.
Sorry,
Was
Snivel.
there ever any discussion about
Yeah,
baptism
I
in the
fucked
last
up.
5 years since the parenting plan was established?
Not at all.
Okay. And as far as you know, was Mrs. Maples objectionable to your son being baptized?
No.
Okay. And can you read the last message there from her?
Oh,
Oh, it was, this is yours. Yeah, can you read that?
so where she responded? Or
Yes.
we do, but that is something that is a milestone in his life, and I would have come for my buddy.
And then read the next message.
So all I have is the cutoff where it says I did my best, and I'm pretty sure it says I took a good video.
Yeah, that's not nicely done.
Just a minute. I'll get back to that.
So she didn't
So
mind
then,
it, she just
just
wanted
to
to be
recap
there.
that situation with the
And
back
you
facing,
denied her. That's not very Christian of you,
did you have
mister.
any knowledge that your son was going to get baptized before it happened?
None.
Tell me about Kristen, your wife, her relationship with Rhett.
She treats him just like if he were hers. I mean, she shows up to everything. As long as, our other son doesn't have something going on, she'll, we have to split then because one has to take one. But she's always looking out for his best interests. She helps with schoolwork. She helps with any special assignments. If she needs to grab something on the way for him, she gets it. We go out of the way, or
Mhm.
she will specifically go out of the way to make him something for dinner if we know that he won't eat it.
Okay. And does she help with, day-to-day needs such as picking up Rhett and things of that nature?
She's absolutely anytime.
What is the relationship between her son Noah and Rhett?
Oh, they're best buddies. They just run around all the time playing, just as two brothers would do. I mean,
Okay.
he tells everybody, "That's my brother." They love each other.
Now, Mrs. Maples is married to Jacob Maples, is that correct?
Yes, ma'am.
And how is your relationship with Jacob?
It's great. I mean, I think very highly of Jacob. I don't think we've had any disputes of anything. I even went out of the way and made sure that my son called him for Father's Day. I mean, that says a lot, I think. So I do like Jacob, and it's been really good as far as communication up until this point.
Okay. And so just to talk about, again, I'm sorry, I'm skipping here, on the communication situation. So aside from those 2 text messages that we have entered earlier where there's some conflict, were there communications between you and Mrs. Maples where there's cooperation?
More than I could count.
And anytime there's some message about, reminders about, hey, Rhett needs this and that, how do you respond to that?
I usually volunteer to get it. If you're asking, if he needs something, just like soccer, I went and made sure that she signed him up for soccer, and I checked if I needed to pay for that. She had paid for it. So I asked if I could get the ball, the shoes, the shin guards. So I provided all that.
Okay. So would you say that you're working together basically for the best interest of Rhett?
Absolutely.
In
That's
that
what I try to
regard.
do every single day.
That's all the questions I have for now, Judge.
All right.
I see the Abby Lynn here. In your community, folks decide on a whim to get baptized. They are at church and they're called to come to the front. Kids especially just walk on up. Yeah, if that was... This is not... I agree with... If it just happens, it happens. I'm not so entirely sure that this was the situation here. It would have been more detrimental to the child to tell him no in that moment. But it's not telling him no. I think, would you like to wait for your mom so she can be here too? That would have been an appropriate question. Now, I understand in the heat of the moment, I understand, but these are some of the things, if the parents are separated or divorced, you have to think about it. Yeah. So it's kind of a dick move. And this is his rendition of it. If you take his word at face value. It's not impossible, it's probably probable. But still. Rhonda, Nick, is it okay to tag you on something on X? It's always okay to tag me on something on X.
Robert, you may cross-examine.
Okay, before cross-examination, in 15 minutes, I have the premiere of Judge Simpson's, the week of Judge Simpson's, what you call it, civil court. So I can't redirect from my Trial Watch Clips channel. It's not there yet in the I can't do it yet, but it will start in 11 minutes. So we will go through this cross-examination, and then I will go get the stream down because I need to have some dinner and stuff. And then I need to speed up because I'm choosing clips here, and I need to speed it up so I get clips for the week. Usually I'm going two times speed, and I'm skipping a lot. For example, I knew early on I wouldn't use this as a clip, so I would have just skipped it. But now, since you're all here now, we are just watching it. So we will listen to this cross-examination, and then I will close down this live stream. And I urge you to get over to the Judge Simpson premiere that starts in 10 minutes. I will have the link for you in a second.
You've been at the job that you've had since, sorry, you might need. So, Mr. Jones, you've been at the job with Toyota Material Handling since 2022. Is that correct? Is that what you said?
No, that's not what I said.
Okay.
I was saying that our what they call it, the BOLD initiative, so it turned over to 4 days a week.
Okay.
That's all I was.
Okay. That's what I was just,
Sure.
you, at the time, you and now Miss Maples y'all were never married, and you had read out of wedlock.
Correct.
We came to court. I think you were represented by Jared Creasy, the now juvenile court judge. Is that correct? Who represented you at the time?
Yeah.
I
I mean, we didn't go to court.
Well, again, the court entered an agreement.
Okay. Sure.
When I say go to court, I didn't mean actually.
I'm not real familiar with.
I apologize. That was inartfully put. But after y'all separated and were no longer living together,
Yes, ma'am.
you got a lawyer, she got a lawyer.
Right.
I represented her, and Jerry Creasy represented you.
Correct.
And we entered into an agreed parenting.
Right.
Ms. Maples was designated as the primary residential parent,
Mhm.
correct? And you got every other weekend, plus Mondays and Tuesdays because she worked late on those
Sure.
days. Is
Yes,
that right?
ma'am.
Excuse me. And then any other time that y'all agreed.
Right.
And for the most part, you and Ms. Maples worked well together.
Yep.
She kept you notified of sickness and doctor's appointments and, hey, he wants to do this.
Sure.
and Changing, I think there was an issue, maybe changing some daycare at some point in time, or, getting enrolled in school. You knew about her getting married and all of that stuff, correct?
I guess.
And then she,
I specifically recall the daycare issue.
right. And then when your life changed and you became involved with somebody else, you made sure to cooperate and let her know, hey, we're serious. We're becoming and we're getting married.
Right.
And, and Rhett was able to participate in
Right.
both wedding ceremonies,
Mhm.
right?
Mhm.
Y'all were able to coordinate that so that Rhett got the best of both parents and got introduced to his new step parents.
Sure.
And again, there's not really any conflict in the fact between you and Miss Maples about communicating when it comes to, for the most part,
Sure.
when it comes
Absolutely.
to Rhett.
Yes, ma'am.
And at some point in time, Miss Maples changed her employment and became employed by the Dixon County School
Okay.
System, correct? You knew about
Yeah.
that?
Right. Well, way after that, but yes, I'm
Right.
right.
And at the time after the adoption of the parenting plan, you had left employment from material handlers,
Yeah. MHI.
MHI.
Yes, ma'am.
And then you got employed by
TMH,
Toyota.
Yeah.
And your initial time, you were still working, when you first went from MHI to Toyota, were you still working
It was the same.
5 days a week?
Yes, ma'am. Yeah.
Okay. But then Toyota decided to work,
Right. They adopted the BOLD initiative.
right? And that's when you became, are you off on weekends, or when you said you work?
I'm always off.
Okay, that's what I wanted to make sure, because the way that you explained it, you work 4/10s with a rotating day off.
Yes, ma'am. Through the week.
Okay, and that's
So
what I
Monday
wanted-
through Friday.
You don't work 4/10s. If you work Monday, Tuesday, Wednesday, Thursday, then you don't go, you're off Friday and then work 4 more days. I just wanted to make sure we understood
Yeah,
what your
it's
rotating
just- it's
schedule is.
just-
It's within the 5 days.
Yes, ma'am.
You're always off.
You could get called out on a weekend, but I don't ever.
Right.
It's kind of like they'll call and ask.
So are you off? You'll work Monday, Tuesday, Wednesday, Thursday, and be off Friday?
No, that's the rotating part. So if I would, let's just say I worked Monday my BOLD day was this Monday,
Uh-huh.
this week. So let's say I was off So next week I'll be off Tuesday, the next Wednesday, the next Thursday, the next Friday.
Okay, that's what I'm saying is you rotate. So you may work, you're off Monday, then you would work Thursday, Friday. I mean, you'd work Tuesday, Wednesday, Thursday,
Yes, ma'am.
Friday. So
Yes,
those are
ma'am.
your 4 days.
Yes,
Then the next week you would work Tuesday.
exactly.
So you would
Well,
work,
I'd be off Tuesday.
you would be
I
off
work Monday, Wednesday, Thursday, Friday.
Yeah, you would work Monday, off Tuesday.
Exactly.
They'd work Wednesday, Thursday, Friday. Then
Yes,
you'd be Monday, Tuesday, off Wednesday, work Thursday, Friday.
Right.
And then it rotates from that.
Yes.
Okay. And so when you changed and when y'all discussed this issue of changing where you would just get, instead of every other weekend and just having him on Monday and Tuesday from after school till she got off work at 7:30. Was the basis of that change her job change or your job change? You understand what I'm saying? Was a job change anything
I
about?
don't think it had anything to do with it.
Okay, that's what I thought. It was just a situation on where y'all discussed
Yeah, I mean, and
that-
once again, it was a good communication.
good communication, and instead of kind of, you get every other weekend, he's like, let's give you 5 days every other weekend in a bulk. So Rhett is there and not come back and forth so much.
Yeah.
And he's adapted well to that schedule.
Yeah.
Your family has adapted well to that schedule.
Sure.
Y'all, have you changed Noah's time? so
That's
that his-
totally between my wife and,
If you'll let me finish my question.
Okay.
You testified that Noah's father gets him every other weekend.
Mhm.
So my question is Noah's every other weekend consistent with yours in getting Rhett? Did y'all
Yes.
make sure that the boys
Yes.
are together?
we make sure that anytime they're together.
So the weekend, your wife, unless there's something that they agree separately, but consistently, routinely, Noah and Rhett are together at
schedule.
your house
Mhm. Yes, ma'am.
on a Thursday through
Yes.
Tuesday.
Yes,
And then the next weekend, when Rhett would be with his mom for the
That's when
weekend,
Noah goes.
then Noah would
Yes,
go
ma'am.
with his dad.
yes, ma'am.
Okay. And that's worked out and the boys have done well with that?
Yes.
And that's
It's all
worked
been
out
good.
great.
Yes, ma'am.
And if I would, in looking at it, you've submitted, and I believe it made exhibit 1. I don't know whether the W-2 and his year-to-date income, was that made 1 exhibit or 2?
There's one exhibit.
Okay. Exhibit 1 had your 2024 W-2,
Mhm.
which reflected your gross income at $61,091.49. Is that right?
Yes, ma'am.
And then your year-to-date for 2025
Mhm.
showed 25,387.32.
Mhm.
If that's what's reflected on there. And if I counted right, you get paid on a Friday?
I think so.
Oh, well.
I don't
it-
ever look at it. I'm
That
sorry.
paycheck stub, I think, so I didn't bring it up here, but I think it had the, my calendar, that is Friday.
Okay.
How do you get paid? You get paid weekly, monthly,
Bi-weekly.
bi-weekly? So
Mhm.
every 2 weeks you get paid,
Yes, ma'am.
and you get paid by direct deposit? or-
Yes.
Okay.
That's what I'm saying. I hardly ever go in there and look at
Okay.
it.
But again, if I look at it on May 2nd, and again, in looking at your stuff, I counted, if you got paid Fridays, that's 18 Fridays from the
Okay.
first of the year until then. So you were on track this year. If I counted the 25,387.32 divided by the 18 weeks, that would leave you about $1,410 a week, you getting paid times 52. You're on track to make a little over 73,000 this year.
Awesome.
Yeah.
Cool.
So my question, and again, we'll talk about the math later.
Sure.
I went to law school because there wasn't a math requirement. So again, I'm
I'm with you.
yeah, whichever, if those figures are correct, you're on track to make, let's say 9, 10, 11, about $12,000, $13,000 more this year.
Okay.
So did you get a pay increase? Because it looks like you're making 77.70, your hourly rate is $33.95 an hour
Sounds right.
right now. And did you get a pay increase from last year?
Probably, yeah.
Okay, do you know?
Not specifically, but
Are you scheduled to get, do they do pay increases?
we just
with-
do like a yearly review, but you never get a specific. Like I know, I mean, my boss told me 1 year it was like 50 cents.
Okay. But again, they just do that across the board usually.
Yeah.
annually.
Yes, ma'am.
So again, if we're looking at you getting 30, and do you know when they do it? I just want to make sure your income.
I think it's in July or June,
Okay.
something like that.
So we can think about this May paycheck stub. You would have gotten your increase by January of 2025, and you might be scheduled for another increase in July, because a lot of companies do fiscal year rather than,
Right.
you know.
Yeah, we do fiscal year. Yeah.
You do fiscal, so from July 1 until June 30. is when they do it,
Yes.
instead of January to
Yes,
December.
yeah.
So you should, for the whole year of 2025, you're pretty confident that you were making $33.95 an hour.
Yeah, that sounds right.
Now, the summer under the parenting plan, y'all do the regular schedule, but each of y'all get an extended
week.
time, a week.
Right.
And y'all been able to coordinate and do that.
Yeah, and actually, some of mine's not even been in the summer. It's been in January most of the time. That's when we plan our vacation. So
Okay. So there's not been any type of controversy
No, ma'am.
in doing that?
Nope.
Okay. Now, these messages that you put in, you just put in 2 text messages to show a couple of isolated instances when y'all got a little snippy. for lack
it's
of a
just
better way to put it.
from where I've changed my phone over, I can only go through so many, but I try my
Okay.
best to go through.
Well, I think the next one would be, were these made joint exhibits or separate exhibits? The 2 text messages?
Separate.
Okay, so I think the
We have a
first,
total of 3 text messages.
the first one that we talked about, that you were questioned about, I wanted to go over.
It would be Exhibit 2. Do you want him to have a copy of it?
Exhibit 2, have you still got one or did it get submitted? Okay. Is this the one, where she texts you, she's in the box and you're just on the plane, is that correct? If I could-
Yes,
Okay.
ma'am, yeah.
So this starts out a text from Hugh. This had nothing to do with us. We didn't care if all 3 of y'all were coaching on the same team. Aaron picked Rhett, I'm guessing, because he had him last year. Did you go to the draft pick? Aaron had no clue that Justin was coaching and that you were helping. It's not Aaron's fault. Give him the benefit of the doubt. He had no idea you were involved with Justin. Who's Justin?
That's my buddy.
Your buddy?
Mhm.
Okay. And so the predecessor to this this text message was, you got angry at her about the fact that Red had gotten picked up by this Aaron to coach his team.
Right.
And
When she
Aaron
knew I
had
was
been his
coming in
coach
to
the year
coach.
before.
Sure.
And then you had said you had coached him for years. That was your word.
I coached for years at Buckner.
And it was 1 year. He
I
had
coached
actually-
him 1 year.
1 year.
Yes.
And then the year after that, you didn't coach and he was on Aaron's team?
Yep, he went to Aaron's team.
He went to Aaron's team.
That's when he moved to Charlotte.
Okay. And he went from Buckner where you coached him, and then the next year he went to Charlotte and he was on Aaron's team.
Right.
And Aaron just kept him. Correct?
He tried to keep it, yes.
He tried to keep him.
Mhm.
But had you signed up officially to coach?
Yes. I did. It
Or-
was
or had
Josh
Justin-
Profit. You get 3 coaches in that age group.
Mhm.
You had Josh Profit, Justin Adams, Josh Profit, and then it was me. So
And-
yes,
So again, making sure that we're clear on this. You had already signed up and run your background check and you were listed as a coach.
yes.
Okay. But you weren't at the pick.
No, I couldn't be at the pick. Only head coaches can go to the pick.
But you got mad at her because of something some other man did.
I got mad because she knew that I was going to coach.
Well, but this draft in Charlotte, again, is not where they're pulling stuff out. I mean, the coaches just get together and do it, don't they?
They get to go in a snake draft. They pick the kids' names.
Right, without
Yep.
parents sitting there saying, pick
It's
my
just
kid, pick
head
my kid.
coaches. Just
Huh?
head coaches.
Just the coaches. So
Mhm.
how was she to know? I mean, why were you blaming her for y'all in the?
Specifically because I reached out to Aaron directly and I asked him,
Mm-hmm.
had he had known, he already knew that I was coaching and he would be on my team. She had responded to me saying, or he responded to me saying that he had to reach out to her and ask her permission to let him be on my team.
Mhm. And she said, and then this is her response. It was nothing to do with us. We don't care if all 3 of y'all coach. He just kept him. And then your response, yes, he did. Josh Profit done the draft. I couldn't make it, plus I'm just an assistant. But Josh told him it was him, Justin, and me coaching.
Right.
Well, I don't know, Kyle. I didn't tell him to pick Rhett. I'm sure he didn't know. I'm just trying to be fair here. I am sure he will resolve it. He's an awesome guy. Is that right? I mean,
Yes. Yeah.
but you got angry at her over something like that.
And I probably went a little too far. I shouldn't have. I'll admit that.
But then you went on in the second page of that. All the drama is because you have issues with my wife.
Mhm.
How about this? Don't ever say anything about my wife. You ever see or hear me talking about Jacob? No, never. But it's easy for you to disrespect my wife and family, and Rhett misses the chance for his father to be involved. That's what you want anyways. It's all on you, just like ripping him away from me by going to Charlotte. Keep him with Aaron. Don't call me for anything unless it involves my son. She responded, I don't have any issues with your wife, never have. I have never said anything bad about her because I don't have anything bad to say. You can coach your child. I have said this multiple times, Kyle. All I said was that I didn't want to be left out and for me to be involved with Rhett. I mean, why do you put your wife in the middle of it?
That was because there was an incident when I coached in T-ball.
2 years prior.
Yes.
So
She
you
got all bent out of shape because my wife came in the dugout to help for one game. Yes.
Which would have been a year and a half prior to this.
Yeah. Sure.
So you think you can't let stuff go?
Oh, I'm pretty good at letting stuff go. but
Okay.
I knew exactly what would happen.
And what was that?
She would raise a stink about my wife helping if she had to help.
The next text message. I just asked you first, but I have to go to Justin's for a little while this evening. I'm about to head there, but I was going to see if you cared if Kimmy picked up Rhett. I'll just keep him, it'll just keep me from having to go as well. If it's an issue, I'll just go anyways. Now, you had said on direct examination that you were already over at Justin's plant.
Mhm.
But on this, it says, I'm about to head there. So were you not telling the truth on your direct examination that you were already
No,
there?
I was about to head to get Rhett.
Oh, you were about to head to get Rhett.
Yeah, I was just trying to make sure if it was okay if
Okay.
Kimmy could grab him.
And you know, and her text message, I can always pick him up and bring him to you. I'd rather do that. No, she could go pick her up and bring him to you. And then you got an attitude again, didn't you?
I just said that's not the point.
That's not the point. Don't worry about it. If it's such a problem, then I don't want anyone else picking him up either. You or Jacob, not your mom.
Yeah, always listen to both sides. Always listen to both sides. Jesus Christ, how long is this? Oh, they are going on for a while. They are going on for a while with several witnesses. All right, folks, I need to get to my dinner. It has been slow cooked for the past 4 hours. So I'm going to cut this out. Now, this won't be on as a separate clip. It's way too long. And frankly, I tuned out a while ago. But you can find the rest of this it's on Judge Wolf's channel. It is Judge David D. Wolf with an E, and it is from May 28th. It is from May 28th, and I stopped now at 4 hours and 34 minutes, roughly. So you can finish this off. This won't be a clip on my channel, but I do have 2 clips here that will go on my clips channel. It is the first case about an a-hole dad, and the second case where the a-hole dad turned out to not be so much of an a-hole and then turned a-hole again, but so did the mother of the children. So those 2 will become clips on my I'll Watch Clips channel. All right, folks, I need to get to dinner, and then I need to get to the rest of my day off, where I go through several of Judge Wolf's days. Then I'm going to check other judges for suitable clips I can present on my clips channel. But thank you, everybody, for showing up. It was so nice to have you here. And do subscribe. Check the videos. I need the hours. And yeah, you all have a good one. And I will see you in the next stream or video. Have a good one. See ya. Bye-bye.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.